You are from CMC and as that institute only, or you are from as a participant as a student?
No,
Both.
sir, I'm from CMC.
You are participating as a student or as a just a coordinator? Or
I'm actually interning with CMC. Yeah. So, as Ganda ma'am had mentioned yesterday about having a senior trainer joining us today, so we have Mr. JP Singh joining us, and I'll be giving a short introduction to Sir before he takes over the course. Thank you for your attendance, sir. Thank you. So, Mr. JP Singh has been practicing in the Honorable High Court of Delhi and in the subordinate courts and tribunals in Delhi since 1981. He was designated as a senior advocate by the Honorable Delhi High Court in March 2008. A well-known civil, commercial, and arbitration lawyer, he has pioneered the mediation movement in India. He was appointed founder organizing secretary of the Delhi High Court Mediation and Conciliation Center, also known as Samadhan. He is presently Secretary General of Madhyam, International Council for Conflict Resolution, and member of the Overseeing Committee of the Delhi High Court Mediation and Conciliation Center. He has received training in mediation in India and also abroad. Having completed mediation training under Indian Master Trainers in 2006, he also attended mediation training program for training of trainers at S.J. Quinney College of Law, Utah, USA in 2010-11. He was a member of the panel constituted by the Honorable Supreme Court of India for recommending legislation on mediation. He also made his presentation before the parliamentary subcommittee appointed to make recommendation on the law. He has conducted over 400 mediations and has been appointed mediator and conciliator in several important and large commercial disputes by the Honorable Supreme Court and the Honorable Delhi High Court, and also commercial organizations. We welcome you, sir.
Thank you so much.
Yes, Ganda ma'am, over to you for the session.
Thank you. So yesterday we had first of all, welcome JP. It's such a pleasure to have you again.
In fact, I have been secretly following the entire program. I was telling Ganda, I wish I could continue, all along. But unfortunately, because of preoccupation, I've not been able to join this workshop continuously. I have, had the pleasure of partnering Ganda in one of the programs that we did earlier. And it's such a pleasure, Ganda, to be here.
Absolutely. And so much learning for me and everyone else. So today we will be looking at the opening statement that we shared yesterday. We looked at the ingredients of the opening statement, but because it's such an integral and important part of the mediation process, we will be looking at how to basically have your own unique opening statement, how your personality reflects through that, and how you build trust, a safe space, and build rapport with your parties while you do that. So it's best to learn while doing it. So we would want to, each one of you to make your own opening statement. And again, there are nothing that is wrong and right, but somewhere as observers, sometimes when we do it ourselves, we cannot make out where we are going wrong or how it's coming across to the other person. So just as observers, we can give you some, some feedback in terms of what statements you're making and how it's falling on the person who's receiving it. And we'll look at that, and perhaps all of us will learn. I can't say perhaps, definitely all of us will learn through that process. Every training that we do, we learn something new. And we have JP who will help us with growing in that space with all his experience. So over to you, JP. How should we start?
Yeah, Ganda, I thought let's have, since you've given them, yesterday I saw that, you explained the whole opening statement, the ingredients of the opening statement. I'm sure you also given them the bullet points as to what are the basic ingredients which should be there. And you also told them about the importance of opening statement. So as you rightly said that there is no unique, way of doing an opening statement. It's not starting from A and going to Z. You have your own style. Everyone has his own style. Question being that you must cover the basic ingredients. And the importance being, and let me tell you this, I have a lot of interns when I'm doing actual mediations who are observing me. And one of the interns said, sir, unlike others, you don't take the phone, because I have always a problem with my wife that, when I'm doing a mediation, I don't respond because, you're not supposed to respond. So I told her, look, the most important part when the participants come to you, they see you for the first time. They trust their lawyers. They don't know who you are. And this opening statement is one which puts you in the hot seat, the seat of the mediator, where people are now going to develop trust. And the important part being that the parties should feel that here is a man or a woman who can really deliver goods. And that can only happen if you create that atmosphere, the safe atmosphere, as Ganda has been telling you, that they feel confident that they can now, there's a person they can fully trust, they can repose their trust in him, and he will be able to deliver. And that can only happen if you give your 100%. And that is the most important part of the opening statement. So let's try, let's go one by one, and we will keep telling you as to how you could have done better. And then each one of you, you've been doing your opening statement. I expect when we reach the last person, he would do the perfect opening statement by that time. So let's start. Any one of you can volunteer. Let's begin.
I'll start.
Yeah, please go ahead.
Okay. I'm Dr. Sunnu Balsara. You can call me Dr. Sunnu. I'm a consultant anesthesiologist in Mumbai for the past 25 years. And I have no conflict of interest with the process. Let me assure you that you have made the right decision to select mediation as the choice for addressing your dispute. As you realize, you've come voluntarily, and whatever you say here will be held in strict confidence. I will not keep any records of what is mentioned here. Just jot down certain notes during the process, which too I will dispose of after the process is complete. Also, I will not testify in courts regarding this matter, if at all it goes into the courts. But one thing I would like to state is that if during our meetings I realize that there is any information related to child abuse, a threat, or statement of a plan to commit a punishable offense, or any imminent threat to public safety or health, then I will be forced to disclose to the relevant authorities. As a mediator, I speak 3 languages, Hindi, Gujarati, and English. I will not be judgmental nor a decision maker in this process. I will only help to facilitate between the 2 parties. And I will be letting you know in what order you should speak and for how long you will speak, and you will respect that authority. I expect you to respect my authority to facilitate the process, help you decide, and finally sign the agreement when the process is complete. Secondly, I expect you to be courteous, willing to listen, communicate, and negotiate. And I also expect you not to interrupt and use inflammatory language. We will meet at the institute, which is a neutral ground. It is extremely comfortable, and this is the agreement to the mediation process, which I want you to sign. My fees will be whatever, such and such. And after the dispute is settled, you will also sign a settlement agreement in my presence. Now, I would like you individually to speak, and I'm giving you a time limit of 15 minutes each party. Thank you.
For a first attempt, very well done.
Thank you.
You have nearly, got all the ingredients right? Now, question is, how do we improve upon it? And the only way that we can do that is, first of all, we have notes. We are we have bullet points because, after a while, after you've been doing mediations, I remember, I went to Chennai for a training and the girl said, look, sir, I sometimes get up at night and start speaking. My name is so-and-so. I understand this language. She says, it's all become in so much in my subconscious. You have to start eat, drink, and sleep mediation. And that's only when, your opening statement will become perfect. What you were doing, you were reading, no problem. We have our bullet points, which will be made available to you in the file. So you can, if you've not remembered a particular ingredient, you can look at to check whether you've actually covered everything. But as we'll go along, you'll realize how important body language is. So when we are communicating with the parties, we need to look at them. See, eye contact is the most important part. So if I keep looking down, parties, you don't even see parties' reaction to what you're doing. Right? So therefore, when you're making your opening statement, you have to look at both the parties when you make that statement. Right? So that's the important part, which you should, slowly imbibe. You can look at one particular aspect, look up, look at the parties, look down, again, look at the next. So that's how the opening statement should be made. One part. Second part, let's get, when you are acting as a mediator, stop actually completely obliterate the word authority from your opening statement. I control the process, you control the outcome. So your authority to control the process, the moment you say, look, because since I'm a trained mediator, I'll control the process. How we'll go about it, that's within my control. But the outcome is in your hands. Right? Instead of saying, I have the authority to tell you or authority to do that. Right? And one more thing. Yes, Ganda did tell you yesterday, about giving a short time, putting parties on a timeline. See, when parties come to you, they are full of emotions. They are looking at a shoulder on which they can cry on. And therefore, you need to permit them to vent. Venting is the most important part, because when Ganda told you about, conflict, there are 3 layers in a conflict. The outer layer is emotions. Unless you pierce through the emotions, you can't motivate parties to settle. So the inner layer after emotions is motivation. And the innermost layer is substance, the real dispute. So in order to reach the real dispute, first I must, pierce through emotions, motivate them, and then only the real dispute will get resolved. So you have to permit them to, continue to vent. They will tell you their stories. And again, if you remember, Ganda said, content is not important. The narrative is not important. Narrative is important only to understand facts as to what is the background. What is important is context. From where those parties are coming. Why are they in this position? Why are they feeling this way? So you have to actually get into the context of the whole dispute. Then only you will be able to resolve it. And therefore, their feelings, their hurt, their ego, till that dissipates, conflict will never get resolved. So therefore, it is important that we permit them to vent. But now question is, if you permit them to vent and they go on and on and on, you see, because it's like a broken record. They will go on repeating. Same thing will go on and on and on. But that's where you will get some tools. You will be, Ganda will give you those tools later. When we talk of communication, there are certain skills in communication. How you can stop this record from going on and on and on. I'll just mention it, and ultimately Ganda will tell you what does this mean, summarizing. See, once I summarize to the parties, look, this is what you're trying to tell me. The reason why they repeat, why do parties repeat? Because they don't know you really actually understood what they are trying to convey. So therefore, the only way to make them understand that you really understood what they want to convey is by summarizing, by telling them, look, what I have heard from you, this is exactly what you're trying to tell me. You are upset about how you were treated. You're feeling hurt. You know, when you say all this, they will stop repeating the same thing over and over again. And therefore, you will be ultimately able to make it concise and precise as to what you want to hear or what you want to listen. You know, there are two words, hear and listen are two different words. So what you wish to listen to. So therefore, one, permit them to vent. Use your tools how you can. Ultimately, those tools will be given to you. How you can make them precise and concise without stopping, without laying down time frames for them. You can still make it concise by using those skills. So therefore, neutrality, you talked about fees, ground rules, you know, confidentiality, you talk about your role, everything else was very well done. Would you like to do this again before we go to the next person?
Yeah.
Now that I've told you a few things, now see in that light how you would like to do it again.
Okay. All right. So I have to remove the word authority, you said, right?
Yeah, don't use that word because
Okay.
as a mediator, you are supposed to have power of facilitation.
All right.
Your authority actually is the trust that they develop into you. That's the only authority that you have. Otherwise, you have no authority over them.
Okay.
And fact that you control the process because you're a trained mediator.
Okay.
Go ahead.
All right. That is okay. I'm Dr. Sunnu Balsara. You can call me Dr. Sunnu. I'm a consultant anesthesiologist for the past 25 years, and I have no conflict of interest over here. Let me tell you that you made the right decision to select mediation as your choice for redressing the dispute. And as you realize, you've come voluntarily, and whatever you say over here will be held in strict confidence. I will not keep records permanently. I will just jot down certain points during the process, which also I will dispose of. I will also not testify in courts regarding this matter, if at all you have to go to the courts later. But one thing I would like to state is that if during the meetings I realize that there is any information related to child abuse or any statement or plan to commit a punishable offense, or if there is any imminent threat to public safety and health, then I will be forced to report it to the relevant authorities. And as a mediator, I am able to speak 3 languages, English, Hindi, and Gujarati. I will not be judgmental, nor will I make decisions on your behalf. I will only help to facilitate the process. And I will guide you as to in what order you would speak and for how long you should speak. And I expect you to kind of be courteous, willing to listen, communicate, negotiate, and not to interrupt or use any inflammatory language. And we will meet at the institute, which is a neutral ground. You'll be very comfortable there. This is the agreement to mediation that I expect you to sign. And my fees are such and such. And after the dispute, I would like you to sign the settlement agreement. And now I would like you to speak turn by turn. And let's start the process.
Very well done.
Okay.
Right. Now, the two aspects which need to be added. Now, we will ask the next speaker, Sonu,
Yes.
to incorporate that. One, about joint session and private sessions. This is how we will be going about it.
Okay.
Right. And secondly, if settlement doesn't happen, then my report will simply say parties have not been able to resolve. So that I will not say who's right and wrong, so that confidentiality, even in my report, when I give my report, would be maintained. See, if there is
Okay.
a settlement, no problem. You will
Huh.
look at the settlement. You will agree to the terms that are said. Then your lawyers will assist you in drawing up the settlement, and that I will then sign it and send it to the court. But in case if there is no settlement, then I will simply say in my report, parties have not been able to resolve. And therefore, confidentiality, I will not get into who's right and wrong because that's not in my domain. So parties feel that trust. And one more thing you must always do after you lay down those ground rules, you will not use language, you will not interrupt each other. These are very important ground rules that you laid down. They help you when parties, are emotionally charged and they use language which is, which hurts. Then you can simply remind them, look, we agreed. We will not. So in the end, after you completed your opening statement, take their consent. Do we agree to whatever I have said so far?
Okay.
Right?
Written consent? Is it a written consent?
No,
or
no,
just
no. Just orally, so that you will remind them when they violate this. You see, they will be talking over each other. See, when one party starts speaking, the other one will say, no, what he's saying is incorrect. So instead of just stopping him, you have to just remind him of the agreement. We agreed. When one person speaks, the other will not interrupt. Please make your notes. And when your turn comes, you may tell your perspective. So this agreement helps you later. As the process proceeds. So therefore, just do these 2-3 things to be incorporated. Now let's have the next person.
All right. Thank you.
And I hope the next person will take it a notch higher. Right? I see the hand up. Vishali, go ahead.
Yeah, thank you. Okay. Good morning and welcome to this mediation session. My name is Vishali Patkar and you can call me by my first name. I'm a trained mediator with sufficient exposure to handle various types of disputes. I understand English, Hindi, Marathi, and Gujarati, and we can have this session in English and Hindi unless either of you insist on any specific language known to me. We are here to mediate between applicant A and defendant D. Before we go ahead and I explain you what is mediation and the process thereof, please introduce yourself. So here I will expect them to just introduce their names and the profession that they are into. Once that is done, I'll move to the next part. I welcome you all to this mediation process and must congratulate you for having chosen mediation as a dispute resolution process for yourselves. Let me first explain what the mediation is. It is a process by which a neutral third party, that is, a mediator, works with the parties in dispute and help them to reach mutually acceptable agreement. In your case, I will work as a mediator, and in my capacity as a mediator, I will only facilitate dialogue between both of you directed towards an agreement in a systematic manner. I will in no case give any decision in your case, and the outcome of the dialogue is in your control. Let me also highlight to you that this is a voluntary process and you have all rights to terminate it at any stage before reaching the agreement. The agreement, however, once reached, is treated at par with the court decree and is binding on both of you and is enforceable by the court. While I will explain the process in detail, remember that it is a confidential process and I am under an obligation to maintain the confidentiality of any matter discussed during this process, except for reporting requirements which I have as a citizen of India under the POCSO law. All the facts discussed during the process cannot be considered as an evidence in court of law in case you are not able to reach an agreement and subsequently decide to proceed with your legal suit. If mediation fails and you are not able to come to an agreement, you are free to pursue your legal suit. As a part of this process, I will ask each one of you to explain your side of the story. Once both of you have made your statement, I may seek to discuss with each one of you individually in private, the process being called as a caucus. Whatever being discussed during the caucus will remain confidential and will not come up on common discussion table unless you have an agreement for the same. If the facts and the data is found to be insufficient, I may ask questions in order to get more information, which can be helpful in reaching the agreement. I may also take down certain notings and will also time and again give summary of whatever you have mentioned. Please feel free to correct me if anything that I summarize in is wrong. Feel free to share as much information as is possible, as same will help in arriving at a solution and be rest assured of the confidentiality of the information revealed. Mediation gives you an opportunity to make offer or accept offer coming from the other side. As such, think of multiple ways and means to make your offer mutually acceptable after hearing out each other's sides, constraints, and limitations. Remember, this is a voluntary process, and you both have mutually agreed to resolve the dispute by coming to an agreement. And while it is not mandatory to come to an agreement, make genuine efforts to resolve the issue by keeping practical approach while making offers. In the process, I may take down some notings which will be destroyed by the end of the session and will not be kept on record. I may make suggestions, though same may not be binding on you for your consideration, and may draw attention to some of the drawbacks of laws so that an alternative approach can be worked on. Remember, this is a time-bound activity and we are required to complete the process within 90 days. We will have all our sessions in the mediation center, which is well equipped with all the basic facilities and ensures confidentiality of the entire process, including the caucus rooms. Now, since I am a mediator and in control of the mediation process, I'll spell down some ground rules which all of us will be bound to follow. We will remain cordial with each other while you may express your feelings emotionally. We will not use any unparliamentary language or tone. We will listen to each other carefully and will not interrupt in between. We will allow the other person to complete his side of explanation. Each one of you will get an equal opportunity to speak. I am obliged to remain neutral in the entire process, and if either of you find me inclined towards the other party, the agreement can be terminated on your request. This is all from my side. If you have any questions about the process or any part thereof, please speak out. If no questions, I will request the applicant to tell us about their side of the story. Yeah, I'm done.
You've gone beyond my expectations.
Thank you.
Shali, and then as I said, there is no perfect way of doing it. You've done it in your own way. It's beautiful. We do it the same thing. I would be using a different language, etc. But then, you've done it in a very, very, very detailed manner. And I think it's been very well done. I think you deserve
Thank you.
In all your Sonu and as well Vishali, there's another ground rule that you can lay down. See, because these days people are carrying telephones, which have a recording facility. Tell them, since the process is confidential, you cannot record these proceedings. One, you cannot use them anywhere in court because no court will permit you to do that. And in case if it is actually brought to the notice of the court may view it very seriously. Intention being that the confidentiality of the proceedings at every stage must be maintained. Some parties are clever. One of the parties actually told me, sir, this was a case where the one matrimonial dispute which was settled and the ornaments were being exchanged. And this woman was trying to film it. And why? Because she said that in their complaint, they had said that, the woman had taken away everything when she left the home. And now they were returning so I said, you can't do this. You see, once parties are resolving disputes, you cannot get into use. You see, one more sentence which is very important that you can use. These are without prejudice proceedings. You use the word, you can go back. You did it in your own way. You said, you can always go back to the court if there's no settlement and start from the same position. You can say these are proceedings which are without prejudice. So it's not whatever you do here, whatever offers you make, Unless you sign, nothing binds you. And therefore, you are in no manner going to be prejudiced when you go back to the court. So that actually builds a lot of trust. It's actually confidentiality of the process. Everything hinges around that. Otherwise, why would parties open up with you? Because in court, the moment a party admits something, the judge will say, okay, record this admission, 12:6, decree will pass. Therefore, you don't make admissions in court. But here, because there is confidentiality, there is trust in the process, that whatever is said in these proceedings will be kept confidential, parties open up. And once parties open up, that's where the settlements happen. That's what I told you. I mean, though the stand taken was that the woman had taken away the jewelry, but when the settlement happened, they agreed to return. So these are the important aspects which we need to keep in mind, that we must always say that these are without, keep repeating it, because these are without prejudice proceeding, confidentiality. That's what builds the trust. Right? And when you said that, whatever we do, instead of using the word caucus, use the word private session. Caucus is a very negative word. I will have a joint session. We are having a joint session, and I can break into a private session. And in the private session, please remember one thing. If you can, how to conduct a private session, in your opening statement, say, look, I will try and give both the parties equal time, because you said you are neutral. But sometimes the party may take a little more to explain his or her position. Don't think I'm taking sides. I'm just trying to understand that party. See why? Because when you sit with a party and there's another party sitting outside and you're taking half an hour or an hour with that party, imagine what is going through the mind of that party, which is outside. I don't know what they are telling the mediator, how they are influencing the mediator. One, keep your private session short. You can have as many private sessions as you want. After you have had a private session, you can go to the other side and come back and have another private session. Nobody stops you. So keep your private sessions short, but tell the parties, I will have a short private session. I'll try to give equal time to both of you. But in case, if I do not, stick to that time, I take maybe say 5 minutes extra. It's only because, don't think I'm taking sides. It's only because I'm trying to understand the other person's perspective. We have had, instances. Ganda told you about impasse. This, mediator came crying to me and said, I was the organizing secretary of the center, and said, sir, I want to recuse myself from this mediation. So obviously my question was, what happened? My child was not well. I specially came for this mediation. I left everything. But look at this woman. I spent a little more time with the husband, and she says, look, I hope my husband has not won you over. My husband has a way with women. And she says, look, this is too bad, and I don't want to continue with this. And why did this statement come? Because in the opening statement, the mediator did not tell the parties that I may take a little longer with one party. See, so if you spend a little more time, look at what is going through the mind of the other person who's sitting outside. And this statement came, my husband has a way with women, I hope he's not taken, he's not won you over. And look at how the mediator felt so humiliated with this statement. So it's important in your opening statement, when you talk of a private session, say that I'll try and give you equal time in the private session, but sometimes I may take a little longer. But that little longer should not be 15 minutes to half an hour. 15 minutes to 20 minutes is fine. Don't keep your private sessions too long, because that's then, the parties start having all kinds of misgivings about the process. Otherwise, I think, Vrishali, very well done. And I'm sure when I said the next person is going to do better, I think we are moving towards a perfect opening statement. Let's see the next one.
You.
Who would like to go on for next? See, when we talk of party autonomy, here we are giving you, thank you so much. Yes, I see the hand up. Praveen. Yes, continue. Because you see, you should exercise that option yourself instead of us calling you upon you. Yeah, go ahead, Ravi.
About 5 years back, I had done one mediation. I was not trained that time. It was, you can say, the partition of a joint family, Hindu family, among the 4 brothers and their family. So now, if I have to put their opening statement in background, everything is done almost 3 years, 4 years back. Everything is settled and everything is over. But I just thought, okay, what would have been the opening? That time there was no opening statement because they were my client for last 25 years. Everybody was knowing everybody, and all the accounts I was knowing for last 25 years. And company then made a very good progress, and we settled it. 4 brothers were partitioned to each. Two. So if I have to do it again, after observing these two good statements, I have not done my homework, but I will try to make it. And
Right.
okay.
You know the difference, Praveen? At that time, you already had the trust of the parties. You said they have been your client for 20 years. But here,
Yes.
look at this. You will be meeting some parties for the first time.
Yes, yes, yes.
And the opening statement actually builds trust. It puts you in that chair.
Yes.
Go ahead.
Yes, yes. See, I am Praveen Nawandar, chartered accountant with 35 years of experience. I am more on the finance side and project funding and all other side. Mediation is one of my passion, and I have been trained mediator. Language, what I am comfortable or I speak is English, Hindi, Marathi, Gujarati, and Marwadi. And you can address me as a Mr. Praveen or Mr. Nawandar. I am comfortable. I have no conflict of interest in any of the parties or any of the assets. I am happy that you have tried for a mediation process which is cost effective, time effective, and which is a neutral process and a secret process, non-adversarial process, which you all have come voluntarily to this process. No sort of any uh, force or any other word, whatever you can use, is been imposed on you. This process will be totally confidential. We will be keeping records for a short period only, just to make some notes. And in this process, we'll be using, as I am a chartered accountant for legal drafting and all this, we'll be using the service of Mr. ABC, the advocate and solicitor. I am supported by my 2 assistants, Mr. A and Mr. B. So anytime if you want to understand some of the financial statement, you can make use of him or take his guidance or help, or you can come to me also. Here in this, because it is an inheritance property, there will be no report of POSCO, threat of harm or injury or death by suicide. Otherwise, if there is anything, I will have to intimate to the relevant authorities. My role will be impartial facilitator, not judge nor or a facilitator. All our decision at the end will be by speaking order, mainly a family partition did, and this process we will try to complete within 3 to 4 months. And time being the essence of, because all our business has come to a standstill because of the various dispute. It is very important that we maintain our goodwill and reputation in the market, and that is not lost. I will control the process and you will control the decision. I will not have any say in the matter as regard as your commercial decisions are concerned. Mediate it in good faith, and I will be willing to listen. I am willing to discuss. We may have a private session, joint session. I will try to explain. I will listen to you. I'll hear from you, and all this process will be carried out at the corporate office, because all are here at office only at Andheri West. We have enough conference room, cabins, and your own cabins. So everything is here, and we will be all courteous not to use any inflammatory language or any abused language, or no Kalagali, video, canteen, camera is all taken care of. My fees for this mediation process will be 5 lakhs and it will be valid for only 4 months. So if you don't complete the process in 4 months, then monthly returnership fees will go on. If you have any doubts, questions, queries, then I'm here to resolve. And once you agree, then we will have the session started.
Great, Praveen. As I see it, you people are nearly like using almost all the ingredients that are required. Now, let me tell you 2, 3, 4 things that you can add. One is if there is a lawyer who's accompanying the parties, acknowledge the presence of the lawyer.
No, he was not present at that time.
No, that's all right.
You-
I'm just saying, I'm just
Yes,
telling
yes,
you.
yes.
In case if the lawyer is there, acknowledge his presence. Tell the parties you are very lucky that you have lawyers who support the mediation process. That removes gives the lawyers a lot of, you will see the body language changing. That you have very good lawyers who are actually support the mediation process. I'm here. I'm sure with their help we will find a solution. Ganda told you that 90% matters get resolved because of lawyers' support.
Yes.
If the lawyers don't want it, nothing is going to happen because lawyers, the parties have trust in their lawyers. Right? So therefore, if the lawyers are there, please always acknowledge their presence. Second, when you say it's a voluntary process, now, it's fine, but what does voluntary mean? So you'll have to tell them, look, if this process is not you feel, because it's a voluntary process, if you feel, now how will you explain that? If you feel this process is not helping your cause, please bring it to my notice. And you see, because it's a flexible process, if I'm not able to help you, you're free to go. Voluntarily, you can go. But question is, please bring it to my notice before you decide to quit. So that to that extent, please bring it to my notice. It's a voluntary process. And in case if I'm not able to, to your satisfaction,
accommodate or adjust accordingly. Then
yeah. And if I can't do it, then you are free to go. Secondly, we have said that we'll use joint sessions, we'll use private session. Parties don't know, the poor things, they have come to you for the first time. What is a joint session? What is a private session? So you must explain to them. The joint session, we'll sit like this as we are sitting now and talk in front of each other. It's important that parties hear each other's perspective. But sometimes there are things which you do not wish to disclose in the presence of the other side. At that stage, either at your instance or I can decide to hold a private session. In the private session, whatever you tell me would be kept confidential unless I have your permission to disclose it to the other side. I'll try in the private session to give both the parties equal time, but sometimes I may take a longer time to understand a person's perspective. Don't think I'm taking sides. I'm only trying to understand. Correct? So how you will conduct the joint session, how you will conduct the private session is important to tell them, because otherwise they don't know what is a joint session, what is a private session. You said you covered it in your opening statement, but you must explain it to them because they don't know. They're coming to you for the first time. So acknowledge the presence of lawyer. Tell them what does voluntary mean. You said it that you've included all the grounds. You've included all the grounds. No difficulty at all. I mean, you've gone beyond my expectations, as I said. I'm just now trying to take it a notch higher by telling you what do these words mean, how you can explain it to the parties so that they understand. What is a voluntary process? What is a confidentiality? Confidentiality to the extent that the court cannot ask me even. I can't be asked to testify in court as to what transpired in these proceedings. My report, like after the settlement happens, you will be signing the settlement. It will go to the court, it will become final. No further appeal. In case, let's say there's no settlement, since these are without prejudice proceedings and confidential proceedings, my report will only say parties have not been able to resolve. And what we use the word at this stage. In your report, why do we use the word at this stage?
Subsequently, they may come up and...
They come back to you. Parties may sometimes, and there are times when we have had parties who have come back to us twice and thrice in matters and said, sir, I wish I had taken that offer which was given to me in my first instance. the reason why all this happens is because parties, unfortunately, for court, lawyers prepare parties. But for mediation, lawyers don't prepare parties. You know, that's why the words used by Ganda, Batna, Vatna. Parties need to understand what are your better alternatives in case if there's a settlement being offered, if there's an offer coming, whether it's good or bad. How will they know whether to accept it or reject it unless they have prepared themselves? See, if I have not gone to the market to find out what is the value of the car, how do I know what the value that is being offered to me is the right one or wrong? I'm only making my own estimation, but the market value may be really not what I'm thinking. See, sometimes like for a property which I want to sell, you know, which is called the endowment effect. For something which belongs to me, I value it more. You know, it's been a lucky property for me. It's a two-corner property for me. So therefore, when the person buyer comes, I tell him, no, this property is actually worth 2 crores. But really the market may be 1.5 crores. So therefore, I need to prepare myself. I need to go to the market, find out. And this is what mostly lawyers don't do. They'll say, chalo dekhenge, wahan pe jo bhi offer hoga, we'll see. But what will you see unless you know whether to accept it or whether to reject it? How will you do it? Unless you prepared yourself. So preparation is a very, very important part. And therefore, you know, sometimes it's very important when you break a session. After doing the opening statement, you've done a session, parties are going, tell them, give them the homework. We've now come so far, we've just discussed this much. These are the things which we need to talk about. Please sit with your lawyer, talk about all this, and we'll meet next time. So you're actually telling the parties, prepare yourself and come. So this opening statement is the most important part. That's the one where you build trust. That's where parties have not been. See, what is the biggest casualty? Once parties are in court, the communication is snapped. They stop talking to each other. Even the neighbors, you know, who are in court, if you see in court, one will be looking east, the other will be looking west. They don't even look at each other. So this is the first time you're giving them the opportunity after the whole dispute started in a safe environment where they can talk to each other. They come to, and secondly, they hear the other person's perspective. You see, because they go on building bricks and walls around the whole dispute. They really don't know from where that other party is coming, what is hurting the other side. So you are giving them this opportunity for the first time after a long time to hear each other. So opening statement, if you know, you said you didn't do it earlier because the parties already had trust in you. But when you now do an opening statement with parties you don't know, this is the only way you build trust. And this is the only way the parties will know that here is a man who will do my job, who will actually help me resolve this. That's the only way you can build trust.
Sir, one more question.
Yes.
Sir, in this partition, we normally find exact 50-50% is very difficult. Suppose the assets are of 100 crore. I can't distribute or they cannot distribute exact 50-50. It becomes 51-49 or 52-48 or something. And it is not like even a cake piece of cake and I can or they can distribute exactly. So that also we need to tell them initially it will be a somewhat compromise and give and take. It will be not exact. See, I have 2 flats. One is of 3 bedroom, one is of 4 bedroom, but the 4 bedroom value also might be equal to 3 bedroom when the partition takes place. Should I have to tell them that exact partition will not exact? It will be not pi to pi, but it will be near about.
Praveen, we are nobody, you know, this is what you do is you are evaluating. Sometimes a 3-bedroom flat may have more value for one party than the 4-bedroom. Because why? It is nearer to his school's children's
Location is important.
It is nearer to my office. The man may accept 3-bedroom. So for him, the value of that 3-bedroom flat is much more than the 4-bedroom. It all depends. And this is all that you learn, you know, when Ganda takes you to negotiation. Today you are using your evaluation. You still, you know, I mean, I always say there are 4 stages of skill learning. The first stage, is unconscious incompetence. I don't know what are the skills required to actually deal with disputes. So therefore I don't know how to use those skills so therefore I'm unconscious, I don't know, and I'm incompetent because I don't know how to use those skills because I don't know those skills. Then comes the next stage where it is conscious incompetence. Ganda will tell you these skills. Negotiation, communication, all these skills will tell you. But then unless you know how to use those skills, you will not be able to use them. So you're conscious of those skills, but you are incompetent. Like riding a bicycle. I'll give you a bicycle in the beginning. You don't know how to ride a bicycle. So it's actually useless for you. Then you will be told, well, look, you sit on the seat like this and start paddling. And this is how you cycle. But what do? Somebody pushes you, you fall. So now he told you how to ride a bicycle, but unfortunately, you are incompetent. You don't know how to use those skills. Then will come a stage of conscious competence. That's where now you know what the skills are, how to balance yourself in the bicycle, and you will start cycling and enjoying the ride on the bicycle. And the last stage is unconscious competence. After you learn how to drive a cycle, you don't ride a cycle, you don't even have to think. You may be thinking about what is going to happen in my office, whether my lunch has been packed or not, whether what is the weather, and you are still riding a bicycle. Your mind is somewhere else totally. So now you become unconscious competence. And this is where you have to go. Right now, you are at a stage of unconscious incompetence. Ganda has not given you those skills so far. So all that what you are now talking about is basically because you are not competent with those negotiation skills. Once you get those skills, you will not make this statement. You leave it to the parties to take a call. I mean, how do you add value in negotiation? What is value? All that will come as you move along. So what parties want, parties know. You see, when Ganda said, in one of the matters, she felt that one party was treated unfairly. She did not get the real thing that's Ganda's thinking. But for that particular party, some parties feel happy. Let's say when the father-in-law in a negotiation, father-in-law is on one side and the daughter-in-law on the other side. Father-in-law is dominating. And so you feel there is balance. There's no balance of power. That's your thinking. But maybe the woman really doesn't mind. Maybe the general manager on one side, the workman doesn't mind. But why should we? See, because we are conditioned by our own biases, with our own stereotypes, with our own prejudices, with our own perceptions. They always come in the way. Which, if you have to remain neutral, you have to take a step back. And you have to stop evaluating. You will get these value judgments in your mind. But you have to take a step back and say, look, this is not my dispute. Not how it's to be decided. Let the parties decide. And you'll find so many times, you may think something different, parties will accept something different. Very simple example I'll give you. I'm taking a little time for you to understand since you said that about that partition suit. A woman came and told me, look, sir, I want this divorce at any cost. I am willing to give up custody of the child. I don't want any maintenance. I don't want any alimony. And so therefore you tell the woman, look, I hope, you've taken proper advice and you realize what your rights are and what you are saying. She says, sir, I know I have understood this thing. So when you are having a private session, you can ask her, help me understand that why are you doing this? Because as we said, we can't get over our own value system. The woman tells me, sir, I have a man waiting who's willing to marry me. He doesn't want me with the child and he won't wait too long. Look at what is more important to the person. You may be thinking that it's actually imbalance. There's power imbalance. But for the woman, no. She really knows what she wants. That's her need. That's what she wants. That's her interest. So let's put our evaluation of the whole thing behind. It's very easy to say to be neutral, but it's very difficult. Sorry, we took a little more time. Now let's go to the next person.
Thanks, sir.
Okay, Subodh.
JP, I'll just add a little
Yes,
bit.
yes, Kanda.
So one of the things I'm noticing a lot is the words that are being used, which JP has already clarified, that when you're talking about joint statement, joint session, private session, you're using the word voluntary a lot, judgmental a lot, which is, we know what it is because we either are very proficient with the language or we've learned it. But for parties, they may or may not, and they may not understand the context also. So always try to qualify it with an example or with some statements that describe. For example, like JP said, if it is voluntary, it means that you are free to exit at any point in time. Just talk to me if you are planning to make that decision. This is not something that you can't exit and you have to stick through to the process. If you're uncomfortable for any reason, please discuss with me, and it's not mandatory for you to complete the process. Another word is judgmental. What does it mean? That I am not here to judge who is right or wrong. I am here to help you find a solution and you find your own solution. So as much as you can simplify the language, do that. What you have been given are just points. Each of those points, you find your own way to communicate in a way where the other person who has absolutely no idea of what mediation is can understand. And the more easier you make it for the other person, the more they feel that they can trust you. You connect. So yeah, that's my little input.
Okay. Dr. Subodh.
Yeah, the bar is already set too high. I'll try my best to be somewhere close at least. Okay. Hi, everyone. Good morning. I hope all the parties are here and all of you are comfortable. Did you have any difficulty finding this place, this location? And is this time suitable for all of you? I'm Dr. Subodh Shirur. I'm a practicing dermatologist. I've done my master's in law, and also I'm a fellow of Insurance Institute of India. I worked in all these spaces, and I'm grateful for the opportunity you guys have given me to facilitate this mediation process regarding the medical dispute at hand. I understand the complexities and sensitivities that are involved in such matters, and my goal actually is to create a space where we can collaborate and explore potential resolutions. And to do this, we could communicate with each other in the languages that I understand, or maybe the languages you guys understand. I speak English, Hindi, Marathi. I understand Gujarati, and I speak Konkani also. I can be addressed as Dr. Shirur or Dr. Subodh as you would like to, or even sir, if that pleases you. I will invite you to share your names. I see there are some lawyers also along with you, and it's a nice thing that you got them who will help you decide what points we should be raising, and so that the solution is made as soon as possible. I would invite you to share your names, identify yourself, and how you would like to be addressed while we go along with these proceedings. I must tell you, thank you for this introduction that you've given, and I'm very happy that you have chosen mediation as a recourse to resolve your dispute. To begin with, let me say that it's a good thing we have sat across the table, and we are not at crossroads. We basically are trying to find a solution to the problem at hand, and the solution is totally at your voluntary. It's on a voluntary basis. You can decide to go on with this process, or maybe at any point of time you think that this is going nowhere or it's not going to help you out, then you have other legal recourses or other recourses which you can pursue. The proceedings that go on here, unlike in a court where it's in, there are people other than the parties who are present, the proceedings here will be kept confidential. Only the interested parties will be allowed to be present here, or with the consent of the applicants and the opposite side. We could get some other people, but we should know in advance, and the other party should have no objection to that. Since these are going to be confidential proceedings, we are not going to keep any records except some notes that I would need to keep, because I don't want to ask you the same questions again and again, especially some minor points or some crucial points which relate to the amount or the issues at hand. When did those events happen? And since these are confidential matters, I cannot be even called in a court of law to say whatever information I have been told in these proceedings. I may be obligated, though, in certain cases where law expects me to disclose that information. Otherwise, all other information is going to be strictly within the four corners of this rule. I would like to tell you what the role of a mediator is. I am not a judge. The focus of our discussion is to seek a resolution that addresses the concerns and the needs of all involved. We have to recognize the significance of this process, not just in terms of the legal or the medical intricacies, but also in terms of the human impact it would carry. And as a mediator, each of your perspective that you're going to present here will hold value for me. And it's my intention to ensure that both the parties feel heard and understood. The sessions generally will be joint sessions, which means all the parties will be present while the proceedings are on. There will be certain circumstances where I need to speak to you separately. When I speak to you separately, it doesn't mean that we are going to have some conspiracy or I'm inclined towards certain party to the exclusion of the other. The idea is to understand the point of view of that particular party, and I would give some equal time to both of you or all the parties that are present here, so that we come to a solution as soon as possible. We are here to explore solutions that not only acknowledge the difficulties faced, but also pave the way for a meaningful resolution. So at the end of the discussions that we have, the proceedings that we have, this will span over a period of 90 days because that's the mandate we have got from the court. So to have this process completed within the span of 90 days, we would have some ground rules which will help us to complete this process. We'll be doing this thrice a week, Mondays, Wednesdays, and Fridays from 9 to 12 noon. And I would be giving equal time to both the parties. We'll start with the applicant, and then the other party can give their points of view. I'm sure that you have a lot to tell each other and maybe even to me, but we would like to use our time optimally so that we come to a conclusion as soon as possible. So we should allow each other to complete their statements without interrupting, because each one will get enough time to make their submissions. We wouldn't like any unparliamentary language to be used here, because that's not the intention of our proceedings here, because we want a resolution and not a provocation or a trigger for further disputes. We have this center where we have different rooms, but room number 206 has been assigned to us. There'll be times when a different room may be arranged. I'm sure all of you are comfortable in this room because we have enough lighting here. We have notebooks, notepads, which have been provided to each of you. If you need anything that anything that you need, feel free to tell the persons who are here to assist you. There's a restroom on the right side outside this room. You may just inform us and then you can use the restroom. The private rooms are where we have the private sessions, where I may speak to you separately whenever there is a need, is on the right, and there is no need for you to feel suspicious if we take you to a private session. The idea is basically to get the facts right, and possibly you wouldn't like to say certain things in the presence of the other party. But such a private session is a practice in the process of mediation, and the purpose is to understand the issue better rather than to make you suspicious. The documentation, as I said, would be limited to the notes that I make. I would also ask you to make documentation, bring some notes in advance when you want to make points, so that you have covered all the points whenever you want to make the submissions. These documentations at the end of the whole process, we'll be destroying it. I would advise you to keep all your mobiles on, you could possibly keep it on silent and not to use that mobile at all for recording purposes, either video or audio, because as I emphasized earlier, it is necessary that this particular process is purely confidential. So nothing goes outside this room in this process. If at all, at any point of time, you feel that this mediation is not going further, you could inform me, and then we can take an exit from this particular process. If at all, I'll be too happy if we go towards a settlement, which is the basic purpose of this particular process. We'll arrive at the settlement terms and conditions, and you are going to decide what are going to be the terms and conditions. I'm here to support you and help you out with those terms and conditions. So basically, since it's a process where it's outside of court, the fees is not going to be too high. I do this more as a social activity. So my fees are going to be 5,000 per session for 3 hours, and that would be divided between the parties that are present here. So let's make the best use of the time we have here. Let's approach this mediation with open minds, empathy, and a commitment to finding common ground, because the ultimate aim is to craft an outcome while addressing the underlying issues and to have a constructive way forward. I encourage each one of you to express your thoughts and concerns openly and respectfully. By doing so, we can work towards a resolution that not only revolves around the immediate dispute, but also helps in fostering a sense of closure and understanding. So I'm here to facilitate a dialogue that promotes understanding, cooperation, and most importantly, a path towards resolution. Thanks for your willingness to engage in this process, and I look forward to our discussions ahead. So I would invite the applicant to make your submissions. Let's try and wind it up, say within 15-20 minutes. I'm sure you would not take more than that. Let's have an overview of the issue at hand. So please go ahead, Mr. So-and-so. Thank you so much.
Gosh, Dr. Subodh, if this is the beginning, I don't know when you are actually into thick of mediation, how you'll do. You really, I mean, if asking for myself, I mean, these are very few people who can use this language. I mean, in the beginning that you used for the whole process. It's not easy, to get used to the mediation language. You know what you did? In the beginning, which we call rapport building. See, mostly mediators will say, okay, let's get down to business. My name is so-and-so, start. You did the first beautiful part by saying you are here, you found any difficulty in finding the place, chai, coffee, tea, coffee, you'd like to have some water. This is called rapport building. And this is a very, very important part of your opening statement. Parties open up. Here's a man, look, you see, they're used to going to the court. Which judge says pani pina hai? Yeah, like, you had problem in finding the court. No judge asks you that. So for the first time, they'll see this change. Here is a mediator who's actually asking them. That builds rapport. Very well done. Rest, I don't want to comment because I wouldn't have been able to do that. And I like that beautiful statement that you said, if the law asks me to disclose, you did not use posh, you did not use a particular, what kind of, please be careful. If law permits me, confidentiality will be maintained. You said it very well. If the law asks me to disclose, I'll be bound to disclose that. So what is it? If they want to clarify, let them do it. But we don't have to put them into fetters by saying posh or human element or like if there's a threat to life, etc. We don't have to get into that. That's very well put. In the end, as I said, take their consent. Whatever I have said, any issues that you don't like to agree to, they'll at that time say, no, sir, whatever you said, we have no problem. Because that consent helps you later. Because when parties get into emotional exchange, then they will, as I said, speak over the other person. And all you have to do is tell them, instead of telling them, please shut up, which is a language which you can't use, tell them, just remind them of their agreement. Sir or ma'am, we agreed when one person is speaking, we will not speak over him. Ma'am, we'll not use this language, we agreed. They will say sorry to you immediately. So therefore, get their consent. If there is no settlement, my report will simply say parties have not been able, because confidentiality at this stage will also be maintained. Because every matter may not result into a settlement. And, why do we keep saying that, our whole purpose is to move towards settlement? Because in India, the whole process started as a court annex mediation. And courts are really interested in settlement because it takes matters off their board. While the purpose of mediation is transformation. When parties come to you and when parties leave the mediation table, they should be transformed. They should be changed. Even if there is no settlement, let me tell you, they'll thank you and go, sir, you did everything that was possible. It is only our bad luck we were not able to resolve. They will still thank you. So therefore, it's the transformation which is most important. They may not resolve at that time. They will resolve 6 months later, a year later. That's fine. That's why we say mediation never fails. We call that a non-settlement agreement. We don't call it a failure report. See how, importantly you choose words. Your report is a non-settlement report, not a failure report. Because mediation as a process never fails. If parties have not been able to settle at that time, they may settle sometime in future. So it's important that confidentiality will be maintained. My report will say parties have not been able to settle at this stage. So they feel, and then, even after it's not, let's say it's not settled. I mean, let's say you are in the mediation process. You still thank parties for choosing mediation. Thank them. Sorry, we were not able to find the solution to the whole problem. Don't worry. Our doors are always open. Please come back again if you feel that you need us. Give them that confidence. Don't tell them, look, there are youngsters, we say, sir, this party was so adamant. He really I thought this matter should have been settled, but because of him, it was not settled. So with the result, you actually give them a bad look or make a bad face when they go out of the mediation table. Why? Mediation room. The reason being because those children feel that it is their failure because the matter has not been settled. Don't get attached to the dispute. It's not your dispute. It's parties' dispute. If they don't settle, they fail. You don't fail. So don't carry this in your heart that you failed. They have not settled. That's their lookout. You've tried your best. You have used all your skills. Maybe it's not the right time. Sometimes we say litigation fatigue has not set in. In the beginning, you remember that statement which most parties made, court mein dekh lunga. I'll see you in court. So, they still have that energy. After 6 years down the line, they realize probably they should have settled. Those 6 years they wasted in court, nothing happened. Then the realization dawns. Then that litigation fatigue now sets in. And then they say, fine, good that, we must sit down and finish it. So in the beginning, sometimes when it doesn't get resolved, doesn't matter. And remember this, your power in mediation is to empower parties. You have no power. You have no authority. I told Sonu, don't use the word authority. You don't have any authority. But your power is to empower parties so that they can resolve their dispute themselves. If you can empower them, you succeeded. That's the whole self-determination, right of self-determination is about this only. They must be in a position to resolve the dispute. And so you need to empower them. Ganda gave you those words of reality testing, Vatna. As you go along, you will understand the importance of all these words. So once you empower them, let me tell you, your job is done. Don't hanker for settlement, because sometimes we keep pushing parties towards settlement. That's not your job. If you feel at some stage parties have got stuck, they don't want to move, they have taken a conscious decision, maybe the court is a better option. See, for some parties at that stage, court is a better option. Because some party really wants to delay the whole process. He really doesn't have the money to pay up. He says, look, I know I have to pay, but I don't have the money. So what should I do? Go back to the court. Another 2 years down the line, maybe I have money, then I'll settle. So for him, court is a better option. So why would he settle? It's party's choice. Leave it on them. But let me tell you, so what if this is, now you are doing this, I don't know how you will do, when you are in thick of mediation. Very well done. I mean, I've never seen this, Ganda, you can second me on this. I've never seen the first opening statement parties or the participants doing like this, the way you people have done. It doesn't happen this way.
Thank you so much.
It takes years of practice.
Yes, it does. Also, the reason, Dr. Subodh I had this conversation with him before joining the course, that he already comes with a lot of experience in medico-legal disputes, and that's reflecting in the way he's understood the spirit of the entire thing, and that's coming out in terms of making parties comfortable and all that. But I also have to appreciate the shift, that from an arbitrator to a mediator, there's a big shift, and he's got it, and he's actually being able to deliver that. So yes, and I think those of us who are just watching, you can see the comfort that you will feel like talking to this person. You'll be able to be open, you'll be able to put out that's what you have to notice. As people, as we are listening to each other, we have to notice, will I be comfortable enough to share about my issues with this person? And as you listen, you also note, what is it that's making me comfortable? And then incorporate that in whatever, in your own style, of course. So yes, I agree with you, JP, and very well done.
Thank you so much. Thank you.
As Subodh, you said, now the notch, the whole quality is a notch much higher. It's been set very high now. Okay. Dr. Sudhir now.
Good evening, I'm audible?
Yes.
Yeah. Well, this is my first presentation for any of this, whether arbitration or this thing. So pardon me if I do a lot of mistakes. And I had good people presenting it well before. So it helps me in putting these things together. Good evening. I'm Dr. Sudhir. I have been a doctor with emergency background, and I have been working as an hospital administrator for last 20 years. Well, I'm very proficient in English, Hindi, and Marathi. I can speak Tulu, and we can always communicate in any other language, which can help you people to solve this misunderstanding, which we are going to sit towards today. You can always address me as Mr. Sudhir or Mr. Rai, and I hope that's comfortable. If there's anything else that you would like to consider calling me, please do mention. I have no specific in conflict of interest in this case, being a doctor, because this case presentation is between a complainant patient and a doctor. So please feel free to stop me at any point where you want me to understand this in better note as a patient, or you want to put a point forward as a doctor, which the other person need to understand. And there's anything that is causing us to have any misunderstanding, we would put our points together. I invite Mrs. Neeta, who's the patient, and Dr. Sudha, who's the defendant, and the lawyer A, who represents Neeta, and lawyer B. Thank you for joining these sessions and making it as a point of mediation for these two, and bringing them to this mediation point rather than going to court, where they can express themselves and probably this can be solved better. I am really happy that we are thinking of this mediation as a process. This process basically is where Neeta with her lawyer A and Dr. Sudha with lawyer B would put up their points, and they would really want to discuss this out. I understand that they do not want to talk to each other. You might initiate with the lawyers putting it up first, but I would prefer if they themselves put up their points, what hurts them more, and probably the other person can really put their viewpoints against it, and this would make us understand these things better. At any point, any of them feel that they want to discontinue with this understanding, they can feel free to do so. But I would really would like to put this to an conclusive understanding, or a understanding which can help both of them to understand these points together and come to some point of conclusion. Please do understand, it's you who will be talking, and at any point I feel that there's some need for documentation from my end, I would pen it down, but it will be only for this period, which I would use it as some point of reference to understand, where I might not ask you again as to what it was. And these documentations are purely confidential. It would not be used to testify against each other in court, and I would not be at any point an witness to these kind of testaments. If there is any point of threat or self-harm that would be discussed, then, or any other matter which would be compelling by law for me to report it in court, I would do. Otherwise, I would really not put any of these points as a testament from my part to the court. My role as a mediator would not be to judge who was right, who was wrong. I would rather like you to understand the viewpoint of the opposite party and really come out with an outcome as to whether this thing can be understandable by both the parties, or it's something that should be considered as a drawback, anything from the other party. And if both of them can understand this or put to it to some conclusion, it would be more appreciative. At any point where I feel this discussion is going into a wrong directions, I would definitely pitch in to bring you to the point which is the main points which you would put it up in down the line as your point for discussion. Having understood this, we would start with Mrs. Neeta, who would spend the first 30 minutes in this discussion, and followed by the first 30 minutes by Dr. Sudha or her team to counter present their thing, and they would alternately spend 15 minutes after that putting up the points of discount or with a good reasoning. This is basically where I would like all of you, probably you can put up your points in form of documentations which can be kept with you, or you can give it to the opposite party to read and understand where, if you feel you can share those paper, but all these things will be kept in good faith in this room, and we shall not be discussing it out. We will not carry each other's paper out. We should be willing to listen. There will be no two parties talking at the same time. We have made it clear that first Neeta, second Sudha, and then alternately as it goes on. We will communicate and make sure that we are talking to each other, not fighting with each other. There will be no inflammatory or sharp words which can hurt each other. We will try to be soft spoken and get to the point which can help us to bring value to this discussion. This venue has been mutually accepted by both of you. So this is the room that we have. We have two glass rooms behind us, which is right for Dr. Neeta. The left one is for Dr. Sudha. If there's anything that we need to discuss as a single party, where you want to put in a point which you do not want the other party to listen to, I might spend 15 minutes with each party, but might spend little more if there is something that might be voluntarily more challenging for me to understand. Please understand these are glass doors, so you can easily see through. But in the meantime, you can also put up your things which you want to discuss. And if there's anything, we can always jointly put these points across each other and try to finish this in 3 to 4 hours, which is designated for us for this room per day. The entire documentation will be within this room. No camera or recordings will be available or to be used at this point here. We have good sufficient lighting. If you need anything more, you will definitely tell us. We can have break points. We have refreshments arranged on the right corner of this room. You have water sufficiently. You can go and have it. You have restrooms on the left outside this room. Please make sure that you are not again carrying any of each other's document out of this room. Whatever documents will be left back. We have shredder on the left corner of this room. So whichever papers which is not common or common, we will be shredding it before we finish the sessions in the next 30 days, which is decided by us as a team to conclude for this before we go off either for a sign off or to the court for further settlement. We have discussed about the fees that it would be on hourly basis. So if there's any extension beyond this, which is 5,000 per hour, will be applicable. We are bound to close these arguments within next 30 days and a sign off on the agreements which each your lawyer firms can document it, read through it, and a sign off with the next 30 days. We hope that we will end well and definitely come to some conclusion. If there's anything that you want to point out, please point out now that we need to discuss, or else we'll start with Mrs. Neeta as the first point of discussion. Thank you.
Again, a unique style, Dr. Sudhir. I mean, you use some words. I said, like, voluntary, you use the word you can discontinue. In case, if I mean, I like those words when you use it for the first time. Now, there are 2-3 things which I would like to tell you. The words defendant or complainant are actually meant for courts. They bring back bad adversarial memories. If Ganda told you even not disputants, the word to be used is participants. That's the neutral word that, parties or participants. That's a better word to use. So we don't use the word defendant. Then don't decide who will start first. Let the parties decide. Who would like to begin? Leave it on them. The more you give them the choice, see, exercising choice is power.
Yes.
That's the right of self-determination. Whoever wants to start, please start. We need to understand what the dispute is. And mostly the person who's not come to the court or been brought to the court will say, sir, he started, they have filed the complaint, let them start. So leave it on them. We don't have to decide for them as to who will start. Now, you had to say about who would start, etc. If you were to explain how the joint sessions are conducted, you will not have to do this exercise. In the joint sessions, so like now I have told you, beautifully explained private session. In the joint sessions, I'll first ask party A, whoever, don't say that Subodh or whoever will start. I'll ask one of the parties to begin. After that party has said his particular, whatever he wants to say, I will summarize so that you feel that I've understood exactly what you said. In case if you feel that I have not understood what you really wanted to convey, you're free to tell me that. After I have heard you, if the lawyer is there, I'll go to your lawyer and ask them in few words to tell me what the legal issues are involved. Then I will go to party B. I'll go to you. So I'll repeat the same thing. I'll ask you to tell me what your issues are or what you would like to tell me. Then I'll summarize it for you. If you feel that I've understood you, then I'll ask your lawyer to explain to me in few words. We always say, ask the lawyer to explain to me in few words because lawyers also don't stop. Once they start, then they will go on and on. So I will ask you in a few words, please tell me what the legal issues are involved in this case, right? So you explained how the joint session will be conducted. So therefore the parties beginning is now taken for granted. They have understood now that the parties will begin. It's not the lawyers who will start. So you don't even have to tell them. So don't start with A, B, let them make that choice. That 30 days, etc., you can, tell them there are advantages to this. I mean, you can use the word that there are a lot of advantages in this mediation process. We have a limited time within which the whole process needs to be wound up. You are not paying any extra money. You are saving lawyers. You are saving time. You are saving costs. You are saving anxiety. You are saving trouble. This is a positive way of, instead of saying that you look at how much money you will be spending, how much court fees you will pay, we use it in a positive way. You will save money. You will save time. You will save hassle. Right? So put it in a positive. These are the advantages of mediation. And in some states, you will even get your court fees back in case if you settle. Right? So these are 2-3 things I wanted to highlight. And please also tell them what will happen in the end. If there is a settlement gets signed, goes to the court, no disputes, every dispute will come to an end. In case for some reason you're not able to resolve, my report will only say at this stage, parties have not been able to resolve their dispute. You are most welcome to come back again. So even confidentiality at this stage, even in my report, would be maintained. Confidentiality, you have to keep drumming it in. And then in case if it is not resolved, it's a without prejudice proceedings. You can go back to the court and start from the same stage when you left those proceedings. So sometimes these are the phrases which give parties an impetus to move ahead and ultimately resolve their disputes. Advantages, and in the end, I said, please take their consent. Because all that you laid down the ground rules, you put in all the 3 ground rules that I talked about, language, not talking over each other, recording. This will help you when they violate the rule. Sir, ma'am, we agreed. We will not do it. And they will immediately, you see, sometimes parties don't want to do it deliberately, but they're so overcharged with emotions, this doctor has ruined my life. He operated upon me like this. Look, I can't now conceive, whatever be the issue. I'm now, paralysis just because of this negligence of this doctor. So that hurt. She'll keep on using that language because, she can't get over it, or the person can't get over it. But you have to keep reminding them, ma'am, we have decided to come here for purpose of resolution of dispute. Any wrong language you think will help us in this process? And we agreed we will not use it. After thinking of a moment, she will say sorry. So she will then try to stop herself. Venting is required. Look, why I keep saying that, when you frame timelines, you're not permitting parties to vent. You can control those same timelines by questioning skills. You will be able to control that when you have learned those skills. Right now, you have not learned those skills. So therefore, timelines may look good, but sometimes parties don't want timelines. Sometimes parties really want to vent. They want somebody to hear them. They say 80% of the disputes get resolved if you give them a ear which listens to the parties. Nobody listens to them. Lawyer, when he gets his fees, he listens to them. Later on, they want to say anything, he'll say, look, I know your case. Lawyer will not listen. They go to the court, the judge doesn't listen to them. When the party wants to say something, the judge says, no, you have engaged your lawyer, let him speak. Nobody listens to them. And this is the only forum where you give them that opportunity. Your dispute, please go ahead. And that's why the summarizing part is so beautiful. It helps the party. See, it serves two purposes. The other party gets an opportunity to hear it second time. See, when our attention span, adult attention span is not more than 7 minutes. So parties lose track of what is being said. So when you summarize, that party gets another opportunity to hear. And that party gets an opportunity to correct you. If you have really not understood the party's perspective, and then after you have really summarized and the party feels understood, they will not repeat themselves. They will stop there. So therefore, your purpose of laying timelines would be achieved when you summarize. So all these are tools which you will be given to you as you go along. So otherwise, I have no words. You people are in your own. And the beauty of this is, Kanda, they are not using those words. They are putting it in their own expression. If you see, I'm sure there is a recording being done. And if you hear this recording, you'll yourself realize none of you repeated each other's, what the way the other person has said. You have done the opening statement in your own way. Of course, the ingredients are there. Ingredients will remain the same. But you've used your own language. You've used your own method of doing it. And I think if you can pick up few hints, what the others gave you, like, it was given by this rapport building was done by Dr. Subodh. These are small hints. When you see, sometimes, how settlements happen. When you do this rapport building and you say, okay, you just start doing small talk and you say, which college did you go to? Which school did you go to? That doctor, whoever is the doctor against whom the complaint is, you don't know him. So you can ask him, sir, which and if he's gone to the same hospital or the same institute that yours, see, there's already a rapport building. So sometimes these small things make all the difference. You see, we are looking at conflict resolution. We are not looking at, therefore I said, we are not looking at resolving 12 lakh compensation or 1 crore compensation, or that's not our job. Our job is, the one of you used that word, we'll be looking at relationship. That's the whole purpose of mediation. How do we judge a good settlement? One which is wise. A wise settlement is a settlement which meets the interest of everyone. Efficient, which is enforceable in law. And third criteria for a good settlement is it builds a relationship. or at least it does not destroy the relationship any further. That's the whole purpose of mediation. And you're doing a pious job. I mean, that's what, I mean, one of the Supreme Court judges said, you are doing the job. Mediation is a job that you do, which is ordained by the Almighty. It's not a profession in that sense. And I still remember those words, when we went to Salt Lake City for our TOT. The professor there, Jim Holbrook, said, JP, what is the difference between an Indian mediator and a US mediator? He says, US mediator is a settler of disputes. Indian mediator is a healer of disputes. See, we give so much of importance to relationship. We don't sue our neighbor because he's actually infracted or he's actually violated your right. His dog came over or somebody walked over into your garden. But in America, they would. That's why you're insured for almost everything in America. Because we believe in relationship. And that's why he said, you are healer of disputes. You don't settle disputes, you heal disputes. That's the difference. Okay, who's the next now? Yes, Preeti.
Good evening, sir.
Good evening.
It is indeed very good to see all of you here today. I am Dr. Preeti Jaikar and I will be your mediator. You may address me as Dr. Jaikar, and I would like to know at this stage how you want me to address you all. I am a practicing surgeon and have been advising and patients' families and the patients for the last 23 years. I'm a trained mediator and I'm fluent in English, Marathi, Hindi, and Tamil, and I can understand Gujarati. Please also note that at this point, I have to declare that there is no conflict of interest from my side with regards to either of the two parties or the matter which is under consideration. Before we further proceed, I would like to express my appreciation to both of you, Mr. P.B. Sinha and Mr. S.K. Jha, for moving forward and trying to resolve your dispute through mediation. A special thanks to both your lawyers who are present here today, Mr. Shetty and Mr. Chaudhary, for facilitating this whole process and guiding your parties through this. I really appreciate that. Thank you. In this primary meeting, I would like to stress upon a few points and set a few ground rules that would be applicable for all who are present here till we conclude the entire process of mediation. Most important point that we all need to address is that this is a voluntary session, which means that at any point in time, if you feel that this is not going towards your satisfaction or you're not happy with the progress of the meetings that are happening, you can let me know that this is the point in consideration that you're not happy with. We can either correct it or at any point in time, you can terminate the process. But please do let me know where we have missed the boat. The most important thing that everyone here present has to understand is that everything that is discussed in this meeting is purely and strictly confidential. Though during the process, I may need to make a few notes along during the session to understand the whole problem better. There will be no permanent records. At the end of the meeting or the end of the entire mediation, the entire notes will be destroyed. I am bound by this rule of confidentiality and I cannot testify in the court of law for or against any of the parties. Let me explain my role as a mediator here. I am not here to pass any opinion or judgment. My aim here is solely to help both of you achieve a dialogue and reach a solution that is acceptable to both of you. We will look to the future and not delve in the past. That is the mantra that we have to go ahead with. At the end of the mediation, we aim that you will reach an agreement that solves this issue and dispute, and with the best of whatever available options are put forth by both parties. I may need in the course of this meetings to hold even private sessions with either of you. And please understand that this is not in taking any sides with any particular party, but it is just to make sure that I understand the issues better. There may be points in the during the meeting that you may need me to know, but may not need the other party to be aware of it. I will need to know the entire issue in detail so that I may help you all to achieve the solution between the two of you. I am not taking any sides here. I will try to make sure that each of you gets equal time. And these are the ground rules that I am hoping that we can follow. As your mediator, I will need to understand all the key issues required. This can come from the parties initially, because I need to hear in their own voice and in their own language, if it is applicable or acceptable to all of you, about what exactly is the issue and how they perceive it, so that we can find a solution, and followed by their lawyers so that I can understand the legal aspects of the whole issues in a few words. We will start the session by listening to one of the parties which have been mutually agreed to between the two. And each will hopefully be completed in a allotted period of time. Most importantly, there will be no abusive language or violence that is tolerated during any session. Both parties must agree to allow the other party to speak completely, without interruption or without comments. Both parties will be given some stationery material in which they can make some notes so that they can highlight these points when their turn is up and when it's their turn to speak. At any point of the meeting, if the party is upset or angry, they may leave the meeting for a few minutes and return back once they're okay. But please kindly let me know what the reason was. Each session as of now has been given a time limit of 45 minutes or 1 hour, but we can always extend it based on mutual understanding. Each side is going to be allowed their own time to speak so that all the key points are highlighted. The other party and everyone present will listen very carefully to what is being said, and the reply can be given when their turn has come up to speak. Please kindly note that we will not be using any recording devices, either from my side or from your side, as there is no prejudice during this entire meeting or the session. And none of this can ever be used in the court of law anyway. So kindly refrain from doing so. We have chosen this venue as a mutual choice to hold all our meetings. From our point as the mediation team, we will ensure that we have privacy, comfort, and a good lighting. Light snacks, tea, coffee have also been provided, water is provided, and restrooms are nearby and functional. If we proceed in the given situation, there is an agreement that needs to be signed by both parties and the lawyers and by me. It outlines the key points that I have mentioned. Please read it in detail. We have agreed as of now for a time limit of 30 days. Simply because we are trying to ensure or adhere to the fact that a mediation is a highly preferred means of settling any issue. It saves us time, it saves us money, and in the long run is helpful to everyone present here, as our aim at the end of this session is to maintain relationships, and we aim to do that at the end. The fees for this particular, the mediation sessions have also been outlined in detail. If at the end of the mediation, we reach a settlement, your lawyers will help you draft it and it will be notarized in court. If unfortunately or by any chance we do not reach an agreement, we hope to end at a good note and a happy note, and hope that we can take the solution ahead. My report at the end of it will only say that there was no agreement or settlement reached at the end of this. If we are all okay with what has been said so far, I would like a verbal consent from both the parties and their lawyers. And if there is any doubt or any point that needs to be addressed or explained, this is the time to do so. Please do. Thank you.
I don't know. You guys are not missing any point. I mean, this is actually wonderful. I think, Ganda, the credit should go to you, the teacher. I mean, of course, this is a very, very intelligent group. I mean, very experienced and intelligent group, but still the language use, perception, parties to tell their issues, how they perceive it. These are things which, don't come on the tongue of people for long. And you use this language. How beautifully you explain the voluntary. What does voluntary mean? That's why I said you people have been using your own expressions. Nobody is copying each other's expression. Fundamentals are the same. You see, still nobody told you about, we'll not dwell in the past and we'll look at the future. We've not even talked about this. I mean, this will come a much later. When we talk of communication skills, there are words that Ganda will tell you later on. How do we do these? You use this. We don't use this, but that's the whole purpose. No problems get solved in the past. Let's move on to the future. And you use that. And of course, you said something about when you're upset, you can leave and come back. Your own way. I mean, this is actually the way when parties are into an impasse situation. This is one of the techniques for breaking impasse. You actually used it without even knowing about it. And I mean, still you've not been talked about how impasses occur and how impasses has to be resolved. I mean, you've still not been given those skills, but you use that private session. You explained it beautifully, and I think the whole Ganda. I mean, they are ready to actually move on with the mediation process. I mean, you explained the process to them. They are ready to go to the next step. I think all of them. I mean, I don't find that any element is missing. In the entire. You even went to the settlement. You even went to the consent. Any questions? You've gone till the last. You've not missed out a little bit. And you are actually. I mean, all of you are paying tribute to each other by taking the whole process a notch higher. I mean, you guys, each one of you, have taken this, to a higher level and a higher level, and not being deterred. That's the beauty of it. Usually, a person feels diffident that people have now said everything, they've done it so well. Will I be able to do that? In this manner? And then always remember this. In the longest journey begins with the first step. Nobody is perfect. And unless you do it, you'll never be able to realize where you can go wrong. And it's only by practice that you come over your issues that you have in the beginning, the little bit of hesitation, whether I'll be able to do it. I don't think any one of you had that. When you did your opening statement, I did not feel any one of you hesitating while making the opening statement. You went in your own way, you've done it in your own way, and I think hats off to you guys. Anyone left so far, Ganda?
Yes, there is Dr. Deepa. Dr. Deepa, would you like to go ahead?
Madam, actually, I'm having some internet issue, so I may not be able to start my video. And
Okay.
I've had a busy day, so I will probably improvise right away. I mean, I have not made anything written, but I will make an attempt.
Okay. Let me then invite till you make your notes. Can I invite Dr. Ketki?
I don't mind starting if she has an issue.
Okay, go ahead then. Go ahead.
I won't be able to start my video. I'm really sorry about that. There is a network issue at my end.
Okay. Okay.
I would probably want to use Hindi or Marathi for giving an opening statement because everybody has attempted in English.
Hindi would be better.
Deepa, Hindi I can understand. Marathi I won't.
I will go ahead with Hindi.
No. Then Ganda will take over. Don't worry. Go ahead.
Okay.
Be comfortable in whichever language you want to do.
No, I am comfortable in both the languages, but I would want to attempt in Hindi because everybody has attempted in English.
Okay.
नमस्ते, मैं डॉक्टर दीपा मुंगी। आज हम लोग यहाँ मिले हैं ये मीडिएशन का प्रोसेस अपना स्टार्ट करने के लिए और ये समझने के लिए कि हम आगे क्या कर सकते हैं। मेरा नाम डॉक्टर दीपा मुंगी है, मैं गायनेकोलॉजिस्ट हूँ। पिछले 19 सालों से बच्चे डिलीवर कर रही हूँ और अभी ये प्रॉब्लम सॉल्व करने की कोशिश होगी। अगर आपको हिंदी में कोई दिक्कत है तो हम इंग्लिश में या मराठी में बात कर सकते हैं, क्योंकि ये 3 लैंग्वेजेस मैं जानती हूँ। गुजराती समझ सकती हूँ, लेकिन गुजराती में इतनी फ्लुएंट हूँ नहीं। आप मुझे डॉक्टर मुंगी करके पुकार सकते हैं, मैडम भी बोल सकते हैं। अब ये जो अपना विवाद है उसके बारे में, उसमें मुझे कॉन्फ्लिक्ट ऑफ इंटरेस्ट जरा भी नहीं है, उसमें मैं एसोसिएटेड नहीं हूँ। और मैं अभी जो भी अपने पार्टीज हैं उनको उनसे निवेदन करूंगी कि आप आके आपके जो प्रॉब्लम्स हैं वो हमारे साथ शेयर कर सकते हैं, अपना नाम बता सकते हैं। Here I would want them to tell me their names. और फिर आपका ये इसमें अभी हम मीडिएशन की जो प्रोसेस है उसके बारे में समझने की कोशिश करेंगे। मीडिएशन ये जो प्रोसेस है, इसका मतलब ये है कि मध्यस्थी, मतलब आपके जो डिस्प्यूट है या आपका जो विवाद है उसमें प्रॉब्लम जो है उसे हम लोग उसका निवारण करने की कोशिश करेंगे, ये देख के कि आपके लिए, दोनों के लिए उसका फायदा हो और अपने को ये समझ में आए कि हम इसमें सॉल्यूशन क्या निकाल सकते हैं। अब जानना, थोड़ी चीजें जानना हमारे लिए जरूरी है। सबसे पहले बात ये है कि ये हम खुद से करने के लिए तैयार है। इसे हमें ये करने के लिए हमको किसी ने जबरदस्ती किया नहीं है, और ये करने के लिए हम लोग खुद से ये प्रोसेस में जाना चाहते हैं। दूसरी बात हम यहाँ पे ये बताना चाहेंगे कि ये जो आप अपना यहाँ पे डिस्कशन होगा ये पूरी तरह से कॉन्फिडेंशियल होगा। मतलब ये 4 दीवारों में जो बात हो रही है ये यहाँ से बाहर जाएगी नहीं। अब लोग ये भी सोचते हैं कि क्या ये हमने यहाँ पे बताया वो बात हमारे अगेंस्ट कोर्ट में यूज हो सकती है क्या। तो अब ये जब सवाल मन में आता है तो इसका जवाब ये है कि यहाँ पे आप दिल खोल के बात कर सकते हैं। यहाँ पे हम लोग कोई लिखा पढ़ी नहीं कर रहे हैं। इसको यहाँ पे जो आपने बातें बताई हैं ये सब बातें हम हम और हमारे बीच में कॉन्फिडेंशियल रहने की हम लोग गारंटी देते हैं। लेकिन ऐसे कई हालात होते हैं जहाँ पे अपना देश का जो कानून है वो बोलता है कि हमें आपकी जो बात है वो बताना जरूरी है। जैसा कोई बच्चे को किसी ने कोई छेड़खानी की हो, या कोई औरत के साथ बदतमीजी की हो, या फिर उसमें कोई चोरी चकारी का मामला हो, तो वो बात तो सामने आनी पड़ेगी। वो तो नागरिक होने के हिसाब से हमको सरकार को बताना जरूरी है, पुलिस को बताना जरूरी है। ये बातें छोड़ के बाकी सब चीजें जो आप कहेंगे और जो हम सुनेंगे वो हमारे बीच ही रहेगा। अभी ये जो मतलब हमने जो रिकॉर्ड बनाना है, तो हम ये तो बोल रहे हैं कि इसका रिकॉर्ड बनाएंगे नहीं, लेकिन कोई भी मीटिंग अगर हम लोग ऑफिस में भी करते हैं तो उसके तो नोट्स निकलते हैं, और वो जो नोट्स रहते हैं, नोटिंग्स रहते हैं, वो मीटिंग के नोटिंग्स रहते हैं, और वो हम लोग तब तक ही रखते हैं जब तक ये निगोशिएट अपना जो मीडिएशन है जब तक चालू रहता है तभी तक हम लोग इसको रखते हैं। इसके आगे हम उसको हम लोग डिस्ट्रॉय कर देते हैं, मतलब फाड़ देते हैं, और हमारे पास नहीं रखते ये सब चीजें। अभी इसके बाद में मैं ये बताना चाहूंगी कि ये मीडिएटर, मतलब जो मेरा रोल है इसमें, वो क्या होने वाला है। एक बात समझ के चलिए कि यहाँ पे जो हम बैठे हैं और हम ये जो सब प्रोसेस कर रहे हैं, इसमें हम आपको जज नहीं कर रहे हैं। इसमें हम लोग ये फैसला लेने की कोशिश कर नहीं रहे हैं कि आप कितने अच्छे हो, कितने बुरे हो, सही हो, गलत हो, या फिर आपने जो किया वो ऐसे नहीं होना चाहिए, या फिर ऐसे होना चाहिए, या फिर आप ऐसे कैसे कर सकते हो। ऐसी सब चीजें हम यहाँ पे बैठ के करने के लिए नहीं है। अब जो हो चुका वो बात तो हो चुकी है अपनी, अब आगे देखने वाली बात है। पिछली चीजों में बैठ के वही सोचने से अच्छा है कि अभी हम लोग यहाँ इसका एक आधा जो है वो उत्तर ढूंढने की कोशिश करें। अभी इसमें हम लोग हमने ये समझना चाहिए कि ये जो हमारी कोशिश है, ये सारी कोशिश हम एक दूसरे के भलाई के लिए करने का प्रयास कर रहे हैं। इसमें किसी का नुकसान करने की, या फिर किसी को हर्ट करने की, या फिर किसी को बुरा भला बोलने की, या फिर किसी को नीचा दिखाने की कोशिश जरा भी नहीं होगी। अब हमें जब हम लोग ये सब बातें करने को चालू करेंगे तो अब निश्चित है कि ये जो सब्जेक्ट है सब्जेक्ट मैटर अपने हाथ में है, जिसके बारे में हम लोग डिस्कशन करने वाले हैं, ये सब जो चीजें हैं, इसमें हमें काफी सारा जो है कि भावनाएं इससे जुड़ी हुई है। ये झगड़े काफी पुराने हैं, ये सारी मसले जो है वो काफी दिनों से है। और देखने के लिए तो ये जो मसला है वो तो सीधा साधा लगता है कि भैया ये हमसे पैसे लेना है या फिर आपसे लेना है, अभी वो दे नहीं रहे हो। लेकिन बहुत बार ये पता चलता है बातों में कि ये जो मैटर हाथ में है ये तो मसला है ही नहीं, और मसला तो कुछ और ही है, और कहीं और जाके ही फंसा है, और कोई और दिशा ले ली है ये मसले ने। तो बैठ के जब बातें होती है तो ये सब सुलझने लगता है। लेकिन जब हम लोग बात करने को शुरू करते हैं तो हमारे जो इमोशंस हैं वो अपने पे हावी होना शुरू हो जाते हैं, क्योंकि क्या होता है कि हम लोग जो चीजें गुजर चुकी है वो दौर में वापस चले जाते हैं, और वो सब जो हमारी अपेक्षाएं थी, आकांक्षाएं थी, और जो हमारे इमोशंस थे जब हम लोग बता नहीं पाए थे, वो सब अभी यहाँ सामने आते हैं। तो मैं आप सब लोगों से ये गुजारिश करना चाहती हूँ कि इमोशनल हो के एक दूसरे को भला बुरा कर कहना, या फिर एक दूसरे को ताना मारना, या फिर एक दूसरे को कोई भी गलत वर्ड यूज करके एक दूसरे को नीचा दिखाने की कोशिश करना, ये सब यहाँ पे नहीं चलने वाला है। अगर एक एक अपने में से एक जन बात कर रहा है तो जितना बनेगा उतना और जितना अपने को मुमकिन है उतना हम लोग शांत बैठने की और सुनने की कोशिश करेंगे, और सुन के अपना जो जवाब है वो हमारे पास रख सकते हैं। अगर याद रखना मुश्किल हो रहा है तो नोट्स निकालने के लिए आपको कागज पेंसिल भी दिया जाएगा, जिसपे आप या आपका भी नोटिंग कर सकते हैं और आपका जो पॉइंट है वो ले सकते हैं। लेकिन एक ध्यान में रखने पड़ने वाली बात यह है कि एक दूसरे की बात काटेंगे नहीं, एक दूसरे का अपमान करेंगे नहीं, और सामने वाले को बात करने देंगे। क्योंकि इसमें सबसे बड़ी बात यह है कि ये प्रोसेस में हर एक को बोलने का मौका मिलेगा, और जो भी आप बात करना चाहते हो या कोई भी पॉइंट जो आप रेस करना चाहते हो उसे हम लोग रिस्पेक्टफुली लेंगे और उसे नोट भी करेंगे और उसको अहमियत भी दी जाएगी। अभी मीडिएशन के बारे में बताना होगा तो इसमें ये बताना चाहती हूँ कि यहाँ पे कोई जज वाली बात चल नहीं रही है या कोर्ट वाली बात चल नहीं रही है, जहाँ पे आप दोनों फरियादी है और हम वहाँ पे बैठ के आपको फैसला देने की कोशिश कर रहे हैं। ये जो मसला है वो आप अपने आपस में ही निपटाने की कोशिश करोगे, और जो भी इसका रिजल्ट रहेगा उसके जिम्मेदार आप खुद रहोगे। क्योंकि यहाँ पे हमारा रोल ये है कि आप लोग बातचीत शुरू करें, एक बातचीत और या डायलॉग जिसे बोलते हैं, अगर एक दूसरे में हम लोग इस्टेब्लिश कर पाएंगे और एक दूसरे में जोड़ पाएंगे तो हम लोग ये मसला सुलझा पाएंगे, ऐसा हमारा समझ है। तो इसके लिए जो जरूरी है वो करवाना हमारा एम है। यहाँ पे बैठ के आप सही या आप गलत या आप गलत या आप सही ये बताना हमारा कोई उसमें लेना देना, मतलब ये हमारा काम नहीं, और ना ये हमारे से उम्मीद रखनी चाहिए। दूसरी बात में एक दूसरे के विरुद्ध में एक भी गलत व्यवहार या गलत शब्द यूज करना मना है। उसके बाद ये जो हमारा मीडिएशन है ये हमारे सेंटर में यहाँ पे होने वाला है, जहाँ पे जो होता है उसमें 2-3 चीजें हैं समझने लायक प्रोसेस की। उसमें ये एक बात है कि आपको जो रूम है ये इसको हम लोग जो करना है इसको हम लोग बोलते हैं कि ये जॉइंट सेशन है। जॉइंट सेशन का मतलब ये होता है कि सारे पार्टीज जो हैं, मतलब आप, हम, आपके साथ आए हुए आपके वकील साहब जो भी हैं, उनके साथ में बैठ के हम लोग इकट्ठा बात करेंगे। जो भी है वो बाय टर्न हम लोग बात करेंगे, एक दूसरे के बाद बात करेंगे। और उसके ये हुआ अपने जहाँ कर सकते हैं। इसमें एक और रोल होता है, उसे कॉकस बोलते हैं। कॉकस का मतलब ये है कि हम अकेले पार्टी के साथ बात करेंगे कि मतलब यहाँ पे साइड में रूम्स हैं जहाँ पे जाके हम लोग एक के साथ इंडिविजुअली बात हम कर सकते हैं। अगर हमें कोई मसला समझ में नहीं आ रहा है या फिर आपका जो कहना है वो हमें समझ में नहीं आ रहा है कि आप कहना क्या चाहते हो, तो आपके साथ हम लोग एक प्राइवेट सेशन रखने की कोशिश करेंगे। प्राइवेट सेशन का मतलब है कि अकेले एक आप ही या फिर आप दोनों में से एक हमारे साथ आएंगे, हम एक दूसरे के साथ बात करेंगे, एक दूसरे के साथ बात करके समझने की कोशिश करेंगे। जितना बने उतना शॉर्ट इंडिविजुअल सेशन रखने की कोशिश करेंगे, ज्यादा लंबा चौड़ा खींचेगा नहीं। और दूसरी बात यह है कि एक दूसरे को सिमिलर टाइम देने की कोशिश होगी। ऐसा नहीं है कि एक के साथ बात कर रहे हैं तो दूसरे के साथ बात नहीं करेंगे, या फिर एक के साथ बात कर लिए तो उसका मतलब ये हुआ कि उनकी बात हमने मान ली। पक्षपात का आरोप जितना हो सके उतना हम करना नहीं चाहेंगे, और ये एम भी नहीं है हमारा। अगर आपको लगता है कि ये कोई प्रकार का पक्षपात हो रहा है तो आप बताना जरूरी है कि आपको कौन सी बात खटकी है और कौन सी बात अच्छी नहीं लगी है, वो हिसाब से हम उसको चेंज भी कर सकते हैं। फिर इसके बाद में हम ये बताना चाहते हैं कि ये जो है ये वैसे जैसे मैंने पहले ही बताया है कि ये कोर्ट में हमारा ना स्टेटमेंट चलने वाला है ना हमारा एविडेंस चलने वाला है, तो इसका रिकॉर्डिंग करना या फिर इसका कोई इलेक्ट्रॉनिक रिकॉर्ड, मतलब आजकल कैमरा आता है, वीडियो वॉइस रिकॉर्डिंग आता है, मोबाइल फोन में ये सब सुविधाएं उपलब्ध है, तो चोरी छुपे ये सब करके फिर कल कोर्ट में अगर आप निकालोगे तो ये अपने कोई शोभा नहीं देगा और कोर्ट भी इसको माफ नहीं कर पाएगा, क्योंकि ये जो हमारा प्रोसेस है उसका अपमान होगा। तो आशा करती हूँ कि आप ये सब नहीं करोगे। इसके बाद में जो हमारे फीस रेडी हमने डिसाइड किए हैं उसका पेमेंट होगा। इसको हम लोग टाइम लिमिट रखेंगे, क्योंकि अगर टाइम लिमिट नहीं रखा तो फिर ये चीजें तो जैसे चल रही है वैसे ही चलती रहेंगी और सालों गुजर जाएंगे। हमारी अपेक्षा ये प्रोसेस से ये है कि ये फटाफट खत्म हो जाए और हम लोग इसका मसला सुलझा के आगे चल पाए। तो इसके लिए इसको हम लोग टाइम फ्रेम रखेंगे अराउंड 30 डेज का। अगर हमारा भगवान ने चाहा और हमारा सब अच्छा गया और सेटलमेंट हुआ तो बहुत बढ़िया बात है, तो इसका हम लोग एक एग्रीमेंट बनाएंगे, ये एग्रीमेंट साइन होगा। पर अगर ये सक्सेसफुल नहीं हुआ और मतलब हम उसको फेल्योर नहीं बोलेंगे, ये समझ के चलेंगे कि ठीक है हमारा जो मसला है उसमें हमें और काम करने की जरूरत है। सब मतलब जो हमने 30 डेज या 90 डेज जो भी हमने डिसाइड किया है वो कम पड़ रहे हैं, शायद अपनी मानसिकता बदलेगी, तो हम लोग इसको ये समझ के चलेंगे कि ये हम लोग आज नहीं कर पाएंगे, इसका मतलब ये नहीं है कि कभी भी नहीं कर पाएंगे, तो इसकी दोबारा कोशिश भी हो सकती है या फिर आप कोर्ट में वापस भी जा सकते हो। तो इसमें हमारा स्टेटमेंट इतना ही रहेगा कि ये जो मसला है हम सुलझा नहीं, ये समय पे सुलझा नहीं है, तो इसका मतलब ये नहीं है कि ये फेल हो चुका है या ये मेथड काम नहीं आई है। तो अभी हम इसको रिपोर्ट देंगे कि वो मैटर वाज नॉट रिजॉल्व, और फिर आप कोर्ट प्रोसीडिंग्स कर सकते हैं। अगर आपको लगता है कि आज आप ये सेटलमेंट करने के लिए रेडी नहीं है, थोड़े दिनों बाद लगता है कि वापस करना चाहिए, तो आप वापस भी आ सकते हैं। मैं इतना ही कहना चाहूंगी। अगर आपको कोई सवाल है इसके बारे में या फिर आप कोई जानकारी जानना चाहते हैं इसके बारे में ज्यादा, जो मैंने आपके मायने समझ में नहीं आए होंगे, तो उसे मैं समझाने के लिए हूँ। अगर कोई क्वेश्चन है तो आप पूछ सकते हैं। थैंक यू।
Deepa, if this was not prepared, then God only help us.
Sir, it was not prepared. I had
No, I'm saying very well done. And especially like you remind me of that. I was when I think Justice M.R. Shah was here, in Mumbai. At that time, he had wanted us. I got a letter saying that some districts in Pune that we want you to go for training. And I told the honorable judge that it's better that you actually have a person there who understands the regional language. It's so important, conversing in that particular language parties understand. And therefore, with respect, I had declined that, saying that I mean it's not correct for me to go there, because I can't translate everything into Hindi, and English is we got so used to English that it may not be possible. Though we did one training in Uttarakhand, it was very difficult, even very simple, English language to be explained to some of the lawyers there. And we had to go to Google, translate everything into Hindi, and did the entire training in Hindi. It was difficult, but we did it. So, but what you did today, is phenomenal. Doing the entire statement and the language that you used to explain, we say it is facilitative, my role is facilitative, but the real, even it was said by, Preeti, and what you said, the real role of facilitation is to establish communication. If you will see when parties come in the beginning, they talk through you. They'll be talking to the mediator, they will not talk to each other. And what you need to do as a mediator is to establish direct communication. Once you achieve that, let me tell you, 80% of the problem is over. if they start talking to each other directly. The venom is gone, all that hurt is gone, all that, that you have pierced the outer layer, what I was talking about. So जो आपने किया, this explain किया कि ये facilitative है और इसमें communication establish करने की बात करेंगे हम. Very well done. Yes, you also talked about establishing, going from past to the future. You nicely explained the joint session and private session in Hindi. I think that was very well done. I think the whole process, the whole entire the opening statement, you got all of you. I don't think you missed out even a single ingredient. And look at it, how you all have done. You've used your own language. Here we heard you in Hindi. Very, very well done. I'm really proud of you people. I'm Ganda is very, very lucky that she has all of you here, and people who can really, really understand the whole process. See, Ganda is what Ganda is doing. I wish I could help her, with every session. What she's doing is creating capacity. Today, the country needs more and more mediators, people who understand the mediation process, and resolve. You see, because ultimately, what are you doing? Bringing peace in society. We create the society we live in. So if you foster peace in the society, that's the society you will live in. And that's the job that you do as a mediator. And doing it in a regional language, I wish you could even do in Marathi, but I won't have been able to understand that. But the Hindi version that you did, I'm proud. Very well done.
Thank you, sir.
And that too, as you said, I was wondering what you're going to do with, that when you said you're not prepared, but you didn't miss out a thing. That just shows your capacity to do, what you're doing. Very well. Very well.
And I think they've understood the process.
That's right.
The way the words are coming out, the way each one, I think they've understood the process. I also want to appreciate the tone that's being used by each of them. It's coming out as, really a tone that's setting the tone for the next conversation to go on. So yeah, beautiful. We have very little time left, so I'm going to invite the last participant, Dr. Ketki Wad. Yes, Dr. Ketki. Can you hear us?
She did put up a hand.
Okay, she says, please unmute me. I think, Dr. Ketki, you'll have to log out and log in again, please. I think there's a challenge there. No, you'll have to do that. It's not happening.
I think she's logged out.
Yeah, she'll log in again because her mic was stuck.
While we wait, can I ask one small question?
Yes, she's
She's
joined.
here.
Yes.
She's here. Then we go ahead.
Hello.
with her.
Yeah,
can
hello.
ask.
Can you hear me? Am I audible?
Yes.
Yes.
Thank you. Good evening and hello everybody. Welcome everybody for this first session of mediation. And let me introduce myself. I am Dr. Ketki Wad. I'm a practicing obstetrician and gynecologist for 30 years. And I've just had a special training in mediation in healthcare. So I welcome you all. And is everybody comfortable enough? Okay, thank you. Let me appreciate you that you have chosen this path of mediation. Try and see if your dispute can be resolved without going to the court. And I thank you very much. Okay, is everyone comfortable with English? Because I can speak Marathi and Hindi as well. So whatever way you are comfortable with, we can speak. Okay. So just initially, let me tell you that I have had no past association with any of the parties, and there's no conflict of interest on my part for or against any of you. Okay. And also assure you that I'll try my best to be neutral and impartial to both of you parties. Yeah. Can you please tell me your names? Yeah. Thank you very much. So again, I welcome you. And I tell you that this is purely voluntary basis process. You can opt out of this process anytime if you feel you can't solve the dispute or want to go to the court. But just let me know about it. Is that okay with you? Okay, this proceedings, whatever now we will be talking in this room will be strictly confidential. We are not going to keep record of any of these sessions later once this mediation has had its closure. Sure, I'll be taking some notes myself and let me understand all the problems, but they will be destroyed soon after the close. Okay, they will not be used as an evidence in court, and I will not be able to go to any court to testify that this was discussed in this meeting or so. So this will be strictly confidential unless the law mandates me to tell some things to the legal authorities that needs to be done, but otherwise it will be strictly confidential. Okay. So you also clarify my role as a mediator now. I am not a judge. I am just a facilitator, and I am going to help you through this process to try and see if you can come up with an amicable solution for your dispute. Okay. First, the process will be like this. Generally, I'll be able to give you some time for the first party. Then I'll summarize whatever they have said. Then I'll go to the next party. Then I'll summarize what they have said. And you can get your lawyers for the next session also. And then you take some legal guidance, some legal points from them in a few words. That would be great. And whatever, then the next session, if you have to say something again, yes, we can do that. Only thing is, please let the other person talk. Don't interrupt in between. And you can take notes. You will have a chance to speak again. So don't worry. Don't think that only one party will speak and we will take some side or something like that. Okay. So this will be a joint session. You all will be present. If required, we may have to have some private session in which we will talk to one party to understand the problem better. They want to share something which they are not comfortable with sharing to the other party, they can share. And that again will be strictly confidential. So we will try to give equal time to both, and don't think that there is some conspiracy or something like that on any type of partiality. We will try to be as impartial as possible. Okay. So again, I'll just have to remind you that you have come voluntarily, so please come in good faith and think about the solution and not the past. That would be better for everybody here. Okay. And only thing is, you will be listening to each other, will be communicating with each other and negotiate with each other. But please see that you are courteous to each other and do not make any inflammatory or derogatory remarks. Okay. You have the authority to take the decision. You are free to take the decision, and anytime you are again, if you are not satisfied, you can opt out and then try the legal proceedings again. Okay. So this will be purely voluntarily basis. And secondly, this may require some multiple sessions. So they will be held in this office. This office, if it is convenient with you, let me know. This has a restroom on one side and a small pantry on the other side where coffee is available, and some small room. You need some room for your discussion, private discussion. So that will also be given to you. So then if after this process, if you think that you are reaching a settlement, very well, the lawyers will help you to draft a settlement agreement. If not, we will not have any documentation. We will just give a final report that these parties have not been able to resolve the dispute at this stage, and no documentation so far. Okay. Do we agree on these points so far? Any issues about what I've said so far? Okay, the fees have already been decided and the time limit as given is about 30 days. Is it okay with you? Yeah. So now can we please start with the proceedings? Thank you.
Ketki, I mean, you kept it very crisp. I mean, this is what I liked. When Ganda said your opening statement should not be more than 5-10 minutes, should not be too long. And so you kept it very crisp. This was all done. I mean, you used the words, you use the right words. One thing that you said, which is for everyone to see. See, sometimes there will be a private party on one side and maybe the hospital on the other side. So there is somebody who's representing the hospital. So you need to ask that person, do you have authority to settle? That authority needs to be asked in the beginning, because at the end of the day, he'll say, look, I have to go back to the board now. And then tell you. So then there's nothing is going to happen. You spend so much of time and the person will go back and say, look, they didn't agree. So therefore, the person who is on the table should be a person who has the authority to take a decision. So if there is an institution or a company or a hospital on the other side, I mean, there could be in these disputes, you can have even an insurance company on the other side. So the person who's actually sitting on that should be asked in the beginning, do you have the authority to resolve? And if you could, bring that authority to and give it when the process starts. Because if the person has no authority, there's no point going through all this. And ultimately the man may come back and say, I agree, but my bosses are not agreeing. So then there is no purpose. No? So therefore that you use that word there, and you actually acknowledged lawyers, you laid down the ground rules. I mean, maybe we could have added few don't record, recordings are not to be done because these are confidential proceedings. You said about no interruption, you talked about language, listening and communicating. I mean, you are using all these words, which are very good, that, and you explained private session. You did not use the word joint session, but you said you will actually, have one party speak and then you will summarize exactly what you're saying. This is how I'll do the joint session. So you don't have to use the words. Therefore, I'm saying you don't have to use the actual words so far as you are actually getting the essence of what needs to be done. And I don't think any one of you have missed the essence, the understanding. That reminds me of my, when we joined the legal profession. Now it's different because you have a 5-year course and all these national law universities have come up. At our time, they used to say when you did not get admission anywhere, you went to law. And so the difference being, and medicine was one thing. I mean, I remember when we did a senior Cambridge, I mean, when I came out, I mean, all of us used to, I mean, the three options: get into IIT engineering, get into medicine, or then, go to UPSC. These were the three options that we had. And one of the reasons why you took law was because law was a subject which was good for UPSC. And that's where we are. But what I am amazed is that your level of uptake. All of you. And I think, Ganda, it's worked very well. I mean, I don't know why more and more doctors don't realize the importance of... You see, it's not about actually resolution of disputes. It's also about life skills. As you will go along, you will realize it's just not about resolving party disputes or hospital patient disputes. What you will acquire here is something which you will use in your daily life. And most of us don't have those role models. We don't have those skills. We don't have communication skills. We may think that, communication is about talking. No, communication is about listening. I mean, that's what we say for adult learning. You need to unlearn what you already think that you know. And this mediation training will make you unlearn and then relearn. And if Ganda, the way she's going about it, I'm sure she will succeed and you will reach that level of unconscious competence. You will be riding the cycle at the end. And so Ganda, very well done. I think I don't need to say anything more on what they have done. And they need to now move on the next stage. I mean, the process you have already explained to them, and how to go through the process. These are those skills which you will be talking about as you go along. Thank you, everyone. Thank you for listening to my tirade, because again, I am a lawyer plus a mediator trainer, so I also speak a lot. So thank you for listening in.
Thank you.
Thank you, sir.
Thanks,
Thank
sir.
you.
Thank you, sir.
Thank
It
you,
was a
sir.
pleasure.
So
Just
we
to-
want you
just-
more often.
Yes, he'll be joining us more often.
No, I will join you wherever I can.
Even
I
in
just
daily
want to
session,
say-
even if you can spare half an hour, 1 hour, you are welcome.
In fact, I was telling Gandha this exactly, like, ordinarily, two of us take every session. Because one, it breaks monotony. Second, it gives opportunity for the other person to regroup the thoughts. And always people have said that synergy you people exhibit when you do the training is totally different. I would love to do that. And I've told Gandha that wherever I can, come in. Since I keep listening to the, session. See, because I'm myself curious. I'm myself a learner. I always say, when one teaches, two learn. You learn, I learn. So I'm always, very curious to learn. And I was actually, when Gandha was doing those processes, I wish I could have butted in, but I had some other things going on at the same time and I couldn't. But I told Gandha that it will be a pleasure to anywhere I can help. I'll like to, help you go along. Because as I said, it's actually our pious duty. We are building capacity. And then that's where you come in. And you people are going to be the torchbearers so far as the healthcare industry is concerned. Because you will go and spread the word. Ultimately, they will respect your word more than what we are telling. Because unless you have experienced it, for a doctor to take out time, I was telling my wife, look at these people. I mean, till 5 or whatever. And anyway, you have long hours. You work the whole day. Then again from 7 to 9:30 to listen to all this, tirade of what we go on, chatting and telling you all this. And the worst thing that for an adult is to be lectured at. Adults don't like lectures. They would like to do things themselves. And that's where maybe a physical training would have been much better. But unfortunately, for some reasons, it doesn't happen. And COVID has taught us a way out. And therefore, we are now doing this online training. But a physical training I have found is much better. If you can, because then you can really
one-day training physical, it will help us.
Of course.
Even 1 or 2 day or post these sessions also, if at least in 1 day,
Yes.
because most of them are from Mumbai, I think.
Yes,
Yeah.
we can organize something sometime. That's
Gandha,
a
if you can do
idea.
that, it
Yes.
will be wonderful. It will be
Yes,
wonderful.
we should. We
One
should.
session physical training, that would be
Yes, we should. We should. We'll plan something out. We have, and it will be a wonderful experience. I just want to just add here, Dr. Sirur may have had a question or a comment, which, if he wants to talk about it now before.
No, I just wanted to fill in the time. It's
Okay.
nothing important. We can discuss that later.
Okay.
The question was, does a mediator get a burnout? So we can discuss this issue at any other point of time. Since we had a senior mediator here, so I thought I would ask this question.
So, Dr. Subodh, this is actually, we always say, we are also lawyers. We wear a different hat. In the court, I'm an adversarial lawyer. When I come and sit on a mediator's chair, I have to change my mindset. I have to change my hat. And if I am tired, if I am really burnt out, I've had a bad day in court, I should not mediate. Because then I'm going to radiate that same kind of feelings to the parties, which is not good. If at any stage you feel burnt out, any stage, because of course, it's not an easy process. We are not counseling. We are not counselors. We are not psychologists. And it is very difficult for a lawyer. That's why we say judges should not mediate. Because judges operate from position of authority. They are used to giving you direction, aise kar lo, aise kar lo, aise kar lo. And while mediation is not about that, mediation is about self-determination. Mediation is about facilitation. So the parties can take their decision. That's why I said your power is to empower parties, which means a lot of persuasion, a lot of using these skills. And if I am myself tired, in fact, one of my colleagues once told me, sir, I've never seen you lose. I mean, people tell me in mediation, I'm very patient. But that day I lost because there was so much of pressure. I had 4 mediations lined up. And this was the 4th session with this man. And every time I would tell him, no, you have to work out your own options and come back. And every time he'll come back and say, sir, let them say what they want. I said, I told you in negotiation, it never works like this. The other side will come out with their own options. You have to decide what is good for you. And he'll say, no, sir, I can't take a decision. My father-in-law will take a decision. I said, this is the fourth sitting that we are having. And again, you are telling me the same thing. And if you are really not interested, if you want to close it, I have no problems. For me, it's only to write a report. I'll write a report if the parties are not interested. If you think court is a good option, go back. Which I ordinarily don't tell parties till I have really exhausted all options. So this junior told me, sir, I'd never seen you like this. Why did you lose your patience? I said, because I had, the pressure of time. I had pressure of other 4 matters sitting on my head. Parties had come from outside. And here is a man who was taking the whole process for granted. He was not moving. So if you are burnt out, please don't do mediation. Because this is an exhausting process. I think, if in Mumbai they have practiced one session or one particular matter in a day, that's the way it should be. Because since I am a trainer since the beginning, I have been part of the I was organizing committee, I was the organizing secretary, and then I continued as part of the committee for so long. All difficult matters are sent to me. And the result is like, I'm under pressure, no doubt about it. But I love to do it because I'm doing some service. But I can't have 4, 5 matters in a day. You see, we don't give long breaks. It's after 3 days, 4 days, looking at parties' availability, we do our matters. And with the result, I have one matter from 3 to 4, the next from 4 to 5, 5 to 6, 6 to 7. And then sometimes I leave the center at 8:39. And then I do my next day's work. I'm briefed for the next day's work. So sometimes it can show on your performance. Please don't do it. You are bound to get somewhere burnt out. It is not an easy process. It's not what we think. Let 2 parties sit together and I am sitting there and say, acha, aap apni problem batao, and there will be a solution. No, it doesn't happen that way. And therefore, it needs time, it needs your dedication, it needs passion. Most of it is, you must do it with passion, that you are doing something good. It's not for money. It will become a profession, let me tell you. In future, because now there's a mediation act on the anvil. I was part of that, we drew up the act. The only reason why they did not make mediation mandatory was because they said we don't have pool of mediators. 3 crore matters pending. If the mediation process goes the wrong way, you will get a bad name. And so therefore, we can't be just doing a shoddy job when you sit in mediation. Then parties will go around talking, because that's how your goodwill spreads. If parties' matters get resolved, they'll have a good word for you. If the parties' matters, you are not able to really take it forward, they will go and say, what is this mediation? The man didn't know a thing, and he actually created a bad precedent. So therefore, let's not do it. We need the capacity building. Today, we need more and more people actually to go through the process of mediation. And let me tell you, this 40-hour training is not what will make you a mediator. This is only a threshold training. This opens up the door of mediation for you. It's only when you practice later on. And one of the things that was said by, look, in the beginning for us, it will be a problem. Yes, but you have the process of internship. As I told you, I have three people, sitting with me when I'm doing mediation. The youngsters and even people who have, after, done their training now, they would like to observe and participate in then you will have after you've done your internship, you'll have a process of co-mediation, where we have 2 people doing it. So, then you get the experience. And then you will start mediating on your own. So it's a process of learning, but you can become good. So don't worry about it that, in the beginning, you will not be able to do it. We did it for chartered accountants, very senior people. After doing the opening statement, after you learn the process, you will realize how it goes. The man was quiet. So I said, sir, proceed. He said, tell you frankly, sir, I'm blank. I've done my opening statement. I don't know now what to do from here. So it takes time. It's going to take time. It's not going to happen, just because we've done 40-hour training. It's difficult because getting the right language, using the right words, all that will come to you. But let me tell you, it is very rewarding. It's not money. One of the lawyers, one of the guys who's been doing it for a long time, he says there's no money in it. And he tells every time on the stage, whenever I have joined him in any kind of seminar or webinar, he always says there's no money in it. You're not getting enough paid. We should be paid. What is it in it for a mediator or a lawyer? I said, I'll tell you what is it in it for a mediator and for a lawyer. I said, if you settle the matter, you have a satisfied client. If you don't settle the matter, you still have a satisfied client. That's what you earn. The man would still thank you, praise you, bless you, and go, even if the matter doesn't get resolved, if you have done the process correctly. So therefore, don't worry about settlements. It's the peace that you will bring about by doing the correct process. That's what you earn. Parties, that venom would have gone. Once they have gone through the process, that venom, when they were not even willing to sit on the same table, and when they go back into court, they will realize they are not really fighting the way they were fighting earlier. And let me tell you, 6 months down the line, a year down the line, they will settle. So you have sowed the seed. That's what you will do. 60%, 50 to 60% matters at the High Court level are getting resolved through mediation. See the number. It's a huge number. As I said, we believe in preserving relationship. And it will really work in our country. So I hope, Dr. Sudhir, Subodh, it is not ultimately, love's labor lost. You would have still done service.
Thank you so much.
Kanda?
Yes, JP.
So you should like to call it a day. I think we've already overstepped the time, and I'm
Yes.
sure
Yes.
we're tired.
Thank you.